With your lordship's permission,
Yes.
may I mention, with your lordship's permission, my lord, may I mention item 111? It's a little way down in the list and it's a very short issue. I need to seek permission from my lord's court before proceeding further in that matter. That is the only reason why I'm mentioning, my lord.
Permission for?
It's a disciplinary action matter. The inquiry is complete. Your lordship had said,
What do you want?
if your lordship could have it at 3:30, because I see that your lordship has almost 6 matters kept at 2:30. I'm aware I'm making an extraordinary request considering your lordship's heavy board. But I'm hoping to assist my lord. I came in from Delhi. I thought I might be able to assist my lord.
We'll try to take up in the second half.
Second half, my lord. So,
My lord,
great.
I'm asking for an interim order for only 3 days, my lords. There's a Ramzan Mela which is coming up, and yesterday the matter did not reach.
One second, one by one.
Fresh matter, my lord. This matter, writ petition was filed last week of February 2025, my lord. I have moved this matter in the third day of March 2025. The lordship was granted a time to quote this matter on 25th of this month, my lord. But unfortunately, what happened that the office had a minor objection. The second set of the paper book is petitioner produced a Xerox copy of the photos. But in first set, we have produced the color photo, my lord. That is the only minor mistake. Therefore, matter is very urgent, my lord. Your lordship may kindly have this matter on Monday, my lord.
Listed today. You remove the office of this list.
I have removed that second set is the first set is the produced, my lord.
So this memo for what?
Memo for posting the matter for preliminary hearing.
23rd April.
23rd. Earlier date, because seepage of water is entering in the farmhouse.
Earlier not possible. Yes.
23rd.
Yes, Mr. Yes.
But I'm asking for an interim order for only 4 days. There's a Ramzan Mela in Shivajinagar where the illegal shops have been put in the pavement and roads, my lords. So yesterday the matter did not reach, my lords. So that's why I kindly take it up on 2:30 today, 3:30, my lords. छोटा सा काम है, my lords. आप एक हुक्म से
Today it is listed.
my lords.
It is listed today.
Yesterday it was listed, it did not reach 108, but
Mentioned yesterday.
yesterday I waited till the end, my lords, but it did not
Could have
reach.
mentioned it tomorrow now.
Oh, okay. Obliged, my lords.
Tomorrow. That is the matter. The court fee is not like 50.
Yeah, yesterday I paid the court fees, my lords. Court fees is paid, my lords.
54,000. If office objections are there, then it will not be taken.
I'll clear the office objection.
Subject to removal of objection tomorrow.
Yes, my lords.
My lord's contempt matter, my lord.
Yes, Mr.
One commercial appeal, my lord. We had an injunction in the commercial court with respect to trademark. Suit, my lord, is then dismissed on the ground, rejected on the ground under Order 7, Rule 11 by the commercial court on the ground that you have not taken the permission of charity commissioner to file the suit. And now my injunction is gone. And my lord,
Then, under the Public Trust Act is necessary in certain.
to sue, my lord, for a matter relating to the trust is necessary under the Public Trust Act. But to sue on the basis of an infringement of a mark, there's absolutely no requirement in law. That has been on that basis. Not I've lost my injunction now.
2nd April.
Beg your pardon, no?
You want to circulate?
Yes, right.
2nd April.
2nd April. Right.
Serial number 7, my lord. My lords, petitioner are intending to engage senior counsel, my lord. May seek 2 weeks time, my lord.
Serial number
7.
7. Let it be called out.
My lord's fresh matter, my lord's contempt. My lord's, it's a civil contempt, my lord's, where
25th of April.
my lords, any date in the first week, my lords, because it's
Not
5 months that they have. It's been 5 months, my lords, that they haven't paid the foreclosure.
Not possible. Yes.
My lord, see,
The appellants were the petitioner before the learned single judge. Matters pertaining to surfacey proceedings, my lord. This honorable court has passed an order staying all the surfacey proceedings, which have been come at halt. It has been since 7 to 8 years, my lord. The entire surfacey proceedings have come at all. I appear for the respondent bank, my lord. Last time your lords directed the matter be listed on 10th of March, subject to the compliance of office objections. The appellants have not been complying with the office objection and the matter is, if your lordship may kindly take up the matter anytime first week of April.
Unless office objection, list.
I appear for the respondent bank, my lord.
Get it listed in the, under the title, removal of office objection. On second, and just invite attention.
My lord. Serial number 37, my lord. The petition is intention to, the petitioner will engage the senior counsel. Kindly.
It will go beyond summer holidays. 18th of June as requested on behalf of the petitioner. Yes,
My lord,
Fresh matter, my lord. Commercial.
40.
Fund number
40.
40.
40.
There is some confusion regarding the ownership of serial number 95. We need some time to conduct a survey by the Tehsildar, my lord.
I beg to appear for the petitioner in the matter, my lord. This matter pertains to a PIL of an open playground that has been encroached by the respondent number 5 passport Seva Kendra. Already about 4 hearing dates, they have taken time. We categorically with documents have produced before this court that the land belongs to the BBMP.
Let it be called out.
My lord, on
That-
fresh matter,
Serial number 24, my lordship. I'm appearing for caveator respondent number 1 to 5 in this matter. my lordship. Senior counsel inconvenience is there, my lordship.
Pardon?
Senior counsel inconvenience.
Correct.
is
What
there.
do you want? What do,
For the appellant advocate. For caveator respondent in this matter.
what do you want?
I need time, my lordship.
That's all. Other side is no objection.
Intimated, my lordship.
Stand out to 23rd of June as requested jointly. Yes.
My lord, serial number 87, we are for the respondents, my lords. Just yesterday, we have filed objections to IAs and also filed applications.
Delay
Which
of
is-
40 days.
My lords,
There is a delay of 40 days.
yes, my lords. Yes, my lord. My lords,
Okay,
so it may kindly be adjourned for 2 weeks, my lords.
Beyond vacation, 24th of June as requested on behalf of the appellant.
83, my lords.
80?
83, serial number
83.
83.
We appear for the,
Same order, 24th
for
of
the
June.
petitioners on there, my lord. There's an application for stay, my lord.
If you are agreeing or not agreeing. Either you agree for time or don't agree for time.
No objection, but a short date.
Short date will not be possible. Short date can go to 29th of April.
My lord, fresh matter, my lord. Commercial appeal, my lord. Suit for ejectment. I am running a commercial establishment and they have filed a execution petition, my lord. Immediate short date. my lord. Fresh matter,
We'll go to
commercial
first.
appeal.
What is the urgency?
Lord, they have filed an it's an ejectment suit, my lord. They have filed an execution, my lord. I am running a commercial establishment, my lord. They will, anytime they may.
25th April.
My lord, in this matter.
Yes, Mr.
Serial number 15, my lords. I appear for the appellant.
15.
2 weeks. 15, please, my lord.
15, 2 weeks. It will go after summer holidays.
Please, my lords.
25th of June as requested by
Great.
the appellant. Yes, madam.
My lord, in this matter, suo motu contempt for.
Which one?
This is a writ appeal,
Which one number?
1887 of 2024.
It is not listed today.
No, it was
Oh.
supposed to be listed on 11th. The Honorable Court was gracious enough to give us a date. Since the appellants are not complying by the office objections, we are not able to get the matter posted. We are for the respondents matter.
You have a respondent.
Yes, madam.
Get it listed in the office of this matters and remind, along with that matter. Both.
Your Lordship, serial number 53. Both the parties are engaged in the mediation, Your Lordship, still on the second round of mediation.
It was stated that both the parties are, that is contempt petition.
That's the contempt petition, Your Lordship.
It
And
was
for the
stated
accused.
by both the sides are engaged in the process of mediation. Therefore, time was requested, stand over to 18th of June.
Much obliged, Your Lord.
Any other mentions? The contempt matters, serial number 1. Mr. Veeraya Remat.
Perfect. The respondent
I
statement.
request time to file reply, my lord. Also fine.
For determination of the
Fixation and determination of the pay within 3 months.
Notice returnable on
Reply, my lord. Writ appeal is also being.
17th of June. I could not find it. Where is this?
Number 2, about the appeal for the complainant. Lords, I filed the above contempt petition with respect to the willful disobedience by the BBMP in respect to the orders of dishonorable court, orders of the learned single judge of dishonorable court in WP number 14271 of 2024, my lords. The relevant paragraphs, my lords, wherein, my lords, paragraph 2, my lords. Learned counsel for the petitioner submits that in a recent decision of this court, in the case of S. Ravishankar versus Bruhat Bengaluru Mahanagara Palike, in WP number so on and so forth, this court has held that permission or sanction cannot be declined in cases where the site is formed in the layout prior to 22/6/2007, the date on which the provisions were amended in the zonal regulations RMP 2015.
You have submitted your documents?
Hello?
You have submitted the.
Please, my lords, I have submitted the documents.
Where you have stated?
My lords, annexure F, my lords.
No, where is the averment?
My lords,
Where is the averment in the contempt petition that you have submitted the documents as observed and directed by learned single judge?
my lords, the learned single judge, my lords, has directed in paragraph 4, my lords, that I am to submit, in paragraph 3 and 4, my lords, that I have to submit the documents to the BBMP.
That is why we are asking, where is that averment that you have submitted?
My lords, annexure F, my lords, the letter.
No
that I have
annexure,
written-
you want averment. Find out and come day after tomorrow.
Great, please, my
Yes.
lords.
Still number 3, Mr. Sachin BS.
Page 16. Roman letter 4 and 6 is not compliant.
Notice returnable on 24th of April.
Still number 4,
My lord, direction is at page 33, my lord. The accused was directed to refund the security deposit of 34 lakhs within 8 weeks, sir. Page 33, my lord.
Not released.
Not released, my lord.
Notice returnable on 23rd April.
number 5.
Lord,
My
free
lords,
complaint.
The bill has been raised, my lords. It has been sent to the treasury. Payment will be made within a period of a week's time may be granted. 1 week, my lords.
Attention of the court to the direct in period of 7 of the order of law on a single judge. Direct, with a direction, amount shall be, it's with a direction that it shall be ensured that the amount as approved for the petitioner to which the petitioner is entitled to shall be credited in the savings account of petitioner within 2 weeks. This contempt petition is disposed.
May I make one humble request? My lord, in the judgment,
Proceeding.
Yes.
Number 6. Accused, my lord. For the complainants in these cases.
What is this?
So this is, my lord, regarding non-payment of terminal benefits of the
what
retired
happened?
employees of the accused company. Yes, they have not paid the interest for the delayed payment. This honorable court has already specifically directed the company to pay the interest for the delayed payment. What is the amount the accused is paying, my lord? I will just ascertain and make my submission, my lord, on the next date or day after tomorrow, my lord. This is the third round of litigation, and the 1992 wage settlement arrears, my lord, are also not paid. The gratuity interest, my lord, is not paid. Leave encashment, my lord, is also not paid. And what is now paid by the, my lord, the accused, I will just ascertain from the parties and make my submission on the next date. Because there are about 8 complainants before this honorable court. They are paid the, my lord, in para 7, my lord, in para 7.
Today, the checks of 90,000,
Yes, Lord.
1,06,000 and 1,01,000
Yes, my lord, yes.
towards payment of
EL and cash. Complainant number 1, my lord,
1, 2.
and complainant number 3 and complaint number 8. Contained in para 7.
Para 7, I'm on para, we are on para 7 only.
They are already at that effect, my lord. Statement, my lord, that annexure, page number 5. Those people have paid at the time of retirement itself, my lord.
They are the 2, 4 and 7. No.
They are, my lord, the
Annexure is what?
annexure is the details of the payment made to the other complaint.
Already.
Just go through the, my lord, the affidavit, make my submission and day after tomorrow. Because, my lord,
Why day after tomorrow?
because, my lord, I have to ascertain for this reason, my lord. This is the third round of litigation. And, my lord, the 1992 arrears, my lord, are yet to be paid. This honorable Supreme Court, my lord, has come heavily on the complaint, the accused. For the kept the, my lord, the legally entitled benefits for all these years. I will just asset paid and what is yet to be paid by the, my lord, accused. The statement, my lord, is just now handed over to me. I will just lord, they take instructions from the complainants and make my submission, my lord. Instead of, my lord, driving them to one more round of litigation,
Kindly give.
So order of learned single judge was only regard to deciding the representation.
Yes.
My lord,
Representations
single
of the
judge is
concern.
only
Where
with
is,
regard-
where is the order?
my lord, only with regard to 1992 pay scale, my lord.
Page 40?
Since your lordship directed
One
me.
second. Page 40.
Yes, my lord.
That's the directions of.
Direction, my lord, is to consider the representations given by the petitioners.
So only payment required was leave encashment.
Leave encashment, 1992, my lord, the wage settlement arrears, and my lord, the interest on gratuity amount. Interest on gratuity amount was also not paid. So I have stated everything in my representation.
Interest.
My lord, with regard to interest, my lord, there are other proceedings, we already filed, my lord. They are claiming compound interest, my lord. We already paid 10% interest.
This is the order passed by the controlling authority. That has not been
As per that,
complied.
my lord, we have paid the interest.
Controlling authority order has been upheld by this honorable court. And they are bound to pay the compound interest for the delayed payment. This is a statutory requirement. I'm not asking anything more than that.
Contempt petition arose from order dated 7th June 2023, passed by learned single judge. Full stop. While disposing of the writ petition, the grievance of the petitioner was noted, which was about the release of arrears of difference of salary in furtherance of 1992 settlement, oblique pay revision by the respondent company. Full stop. Learned single judge, without expressing an opinion on the merits, directed the respondents directed respondent 2 and 3 to consider the representation of petitioner. Full stop. In consideration of the representation, it is an admitted fact that only aspect remained was with regard to payment of leave encashment. Full stop.
That is not the only one, my lord. Kindly, my lord, bear with me for a moment. That is not the only item, my lord, I have sought. Apart from leave encashment, lord, interest on gratuity, my lord, there is an order passed by the controlling authority for payment of compound interest for delayed payment. And in addition to that, my lord, the 1992 wage settlement arrears, my lord, have not been paid. Before the Honorable Supreme Court, they have undertaken to pay the interest, my lord, for the delayed payment. In my case, my lord, no such interest has been paid. It goes contrary to the judgment of the Honorable Supreme
You
Court.
have said it more than once.
Sorry, my lord, just because, my lord, this is my anxiety, my lord, the petitioner.
No, we will not tolerate any interruption in course of the dictation of the order.
I'm sorry.
Whatever you want to submit, submit after the orders.
Yeah, I'm sorry, my lord, for that.
Just please take your seat, both of you. Please take your seat.
Please.
You're just snapping the link of thoughts. Yes, what did you write last time? In course of the hearing, the court had occasion to pass the following order on 18/3/25 and quote the order dated 18/3/25. Today, when the petition comes up for consideration, learned advocate Mr. So-and-so, the respondent files compliance affidavit, He stated that he invited attention of the court to the averments made in paragraph 7 of the affidavit. The relevant part is extracted here in below. So I'd order dated once produced herewith. Full stop. The payment due towards leave encashment to petition number 1, 3, and 8 is now being paid by way of demand draft for rupees 90,130 dated 21/3/25, rupees 1,06,955 dated 21/3/25 and rupees 1,01,243 also of even date drawn in favor of the respective petitioners. It is undisputedly stated that the rest of the petitioners have already been paid the amount, full stop, the details of which is found not in annexure A to the compliance affidavit, full stop. Learned advocate for the respondent has handed over the checks as aforesaid demand draft in favor of the petition number 1, 3, and 8 to learned advocate for the petitioners who has accepted the same today to be handed over to the petitioners concerned paragraph. The above conduct on part of the respondent amounts to compliance and substantial compliance of the order of on a single judge, full stop. The doctrine of substantial compliance will apply. The contempt proceedings are liable to be dropped in view of the compliance as above. Paragraph. At this stage, learned advocate for the petitioner stated that the petitioner has also a claim towards interest on the gratuity amount, full stop, which was also part of the representation. Full stop. The court is of the view that for the said part of interest, the petitioners may take out, if advised, independent proceedings in accordance with law, in respect to which this court, however, does not express any opinion. Yes, next. Yes, somebody wanted time here.
Yes, my lord. For the petitioner, my lord. My lord, petition for farmers. The 2 acres land was granted.
The proceeding, very well. Yes. Yes.
The 2 acres land was government land was granted to SW construct social solid waste management unit. So they made a representative 31st, my lord. My lord, the petitioners are requesting, they're intending to engage senior counsel, my lord. They're seeking 2 weeks time, my lord.
Very good. Very good. Yeah. Yes.
Petitioners needs 2 weeks time for engaging senior counsel, my lord. I informed the respondents also.
Senior counsel is appearing
Senior counsel they will engage me.
on his way. On his way.
Sorry.
Senior counsel is on his way to this court.
No, my lord. Our senior is out of station. They are going to engage another senior counsel.
Another senior.
Senior counsel.
If he is also out of station. When do you?
2 weeks. 2 weeks.
No, 2 weeks. 2nd April at the best.
Any date.
At the request of learned advocate for the petitioner, who stated that the petitioner wants to engage senior counsel, stand over to.
Great.
2nd April. Full stop. Learned additional government advocate Srimati Neelofa Rakpar would request that since the petition is already listed once, it may be posted at 2:30 on that, ordered accordingly.
Much obliged.
Eight, I appear for the petitioner, my lords.
What is this?
Number eight.
Eight.
Eight, I appear for the, let's, this matter may be taken up along with WP number 1741. This is again a public interest litigation, my lords. It may be tagged along with this matter and it may be taken up together for hearing.
Along with?
WP number 1741. 25, my lords.
It is listed or going to be listed?
My lords?
It is listed or going to be listed?
It should be listed, my lords. It had been filed together, my lords. But that matter probably should have been spilled over by a day or two, my lords, for being listed. Both pertain to a property which came to be notified, my lords, in Patan Panchayat without observing the fact that a buffer zone of about 25 meters has to be left from the center of the road, my lords. Without considering the same, my lords, they have approved the plan sanction, my lords. Also, my lords, it may be held together as my submission. Same petitioners.
Honored advocate. For the petitioner's purpose, request that this petitioner be listed along with,
Next matter.
since both
Next.
have the similar subject matter. Paragraph. Both shall be listed on 8th of April,
Much obliged.
provided that paragraph before the next date of posting, office objections in writ petition number 1741 of 25 shall be removed, failing which the said petition shall automatically get dismissed.
It has been already
without
removed, my
reference to our order of the,
Much obliged.
yes.
Here for the petitioners. This is a property, my lord, which belongs to the Hubli Dharwad Municipal Corporation. A request is made, my lord, that this property be allotted to the Congress party, which is respondent number 4. That is opposed because, my lord, this property is adjoining a reservoir which deals with water requirements of Hubli Dharwad. And the decision of the council is that this cannot be allocated to any party. And therefore, my lord, the commissioner could never have then sent it under section 176 of the Municipal Corporations Act to the government for approval. And that is what is done. The approval, my lord, is that this property be allotted to respondent number 4 at 5% of the guidance value.
So it was sold to the corporation.
Lord, it
sold
was
to the
handed over by the
municipal corporation.
Yes, no, it was handed over by the railways. It was originally the railway property. It was then handed over, my lord, to the municipal corporation for, as it was required for a reservoir. There's a tank there.
Is that? Is it reflected somewhere that it was a reservoir?
I beg your pardon, my lord?
That aspect is reflected somewhere.
That is reflected, my lord, in the deposition of a witness of the corporation who made a statement in
No
a,
document.
I don't have a document note for that. That document is not there. But in any event, there is no dispute that the property belongs to the corporation.
I'm for the railways. I've sought instructions. There may be some document, not, originally it was our property. So we had, my instructions are that it was given for the purpose of a
This
reserve.
land is, that is site, what is that?
It's a
That is property bearing CTS number.
4553 of stroke B.
So that is what? That is open land.
Open land. It is adjoining, my lord, a reservoir. And it is for the benefit of the reservoir that the land exists. Because if the reservoir is to expand, then that entire area will be required.
Otherwise, it belongs to corporation
It belongs not to the corporation.
or railways.
No, it doesn't belong to the railways. No, it belongs to the corporation.
Originally it belonged to the railways. My initial instructions are that it was handed over to the corporation for the purpose of formation of a reservoir.
Well, let him file an affidavit.
Anything to show that?
No, my lord. There's no material.
My lord, today is the first hearing. If your lordship gives me some time, my lord, I'll be able to.
And what they are doing?
If it is a
Now, my
fact,
lord, they have passed a government order in which they have said that they'll transfer the property from the corporation to the Congress party at a consideration of 5% of the guidance value. Without any public auction, none of that is done. It is a special allotment made, my lord, by the government to the Congress party. That's the order. If your lordships can you take page 71. The council, my lord, has rejected it. The corporation says we can't hand over this land.
Suppose you are not able to produce any material to show that it is part of reservoir. Then what is the outcome?
But either way, my lord, whether it is railways property or otherwise, there is no dispute that it is a property of the corporation. That is not disputed.
Where is that government order?
Yes, my lord. Please see page 71. The translation is at page 71, my lord, and lordship may kindly see the subject on right at the top. May I just read, my lord? Subject on the top, right at the top, immediately after Government of Karnataka proceedings. Land in Hubli Taluk CTS number so-and-so, owned by corporation, has been requested by Karnataka Pradesh Congress Committee to hand over for construction of a Congress party building regarding. Then below the references, a letter from Commissioner. We don't have a copy of that. Single file and Karnataka State Government Order dated 26/2003, which not actually forbids such transfers. Proposal. With respect to the above subject and reference cited one above, Shri Santosh Lad, Honorable District Minister, and by reference number 2, Shri Vinay Kulkarni, former Minister and MLA, 71 Dharwad Rural Constituency, by reference 3 above, Shri Prasad Abhaya, MLA Hubli Dharwad, and letter by reference 4 above submitted by Nagaraj Gauri, General Secretary Karnataka Pradesh Congress Committee have requested in their letters to hand over the land bearing CTS number 4553B, City Survey Ward number, measuring extent of 2988.29 square meters at the rate as per government guidelines, or lesser than that, for the construction of Congress Party office building. Further, Commissioner HDMC Hubballi have submitted the proposal to District Municipal Administration Bangalore in this regard. While reference number 2 above, Director Department of Municipal Administration Bangalore submitted the proposal to government with single file number so-and-so as under. Proposed property belongs to municipal corporation. To dispose or hand over municipal properties other than certain purpose, there is a provision in the government guidelines. Such properties can be disposed only from public auction. In this matter, the property has to be disposed or allotted to the process of public auction only. Proposed matter is not being approved in the municipal council. Honorable District Minister Dharwad District requested to hand over this property for the construction of Congress office building, and the Congress party is ready to bear the expenditure as per the present guidance value fixed by the government, or lesser than that amount. Treating this as a special case, a proposal is submitted to the cabinet meeting seeking an approval. As per Karnataka Municipal Corporations Act 1976, it is necessary to get the prior approval from government before selling or leasing the corporation property. Proposal submitted by the Director, Department of Municipal Administration, Bangalore, to hand over land bearing CTS number 4553, measuring 2988.29, for the construction of District Congress Party office building was discussed in detail by the government, issued an orders under. On the basis of proposal to hand over the land bearing CTS number 4553, City Survey Ward number so-and-so, measuring an extent of 2988 square meters for the construction of District Congress Party office building, it is being considered as a special case. An order is issued with an approval, and by fixing the value at the rate of 5% of the present guidance value. And under the following conditions, said land is allotted only to construct district congress building. Other than the said purpose, land should not be used for any other purpose. It shall not be sold or leased. If it is allotted, if the violation, it will come back. And your lordship will see, my lord, they refer to in reference number 3 at the previous page, a resolution of the government dated 2/6/2003, which my lord will kindly find at annexure E, my lord, at page 44. This is the proceedings of the government, my lord, where they've said in what circumstances, what property of the corporations can be allocated.
Eight, 789. 8789 of 2025.
And Lordship may kindly see in this matter, can you see section 76? Just, my learned friend was. The Lordship may kindly.
What?
We'll have file our objections, Manoj, kindly grant 2 weeks time, Manoj. Till then, there's no urgency as such in that sense.
If you're not selling the property and transferring.
There's no question, the order has already been passed, Manoj. Insofar as till then, next date of hearing will not, nothing is going to happen between now and filing of the objections.
No, if you, my learned friend says nothing will happen, it's all.
I mean, my learned friend can move the matter if, once we make a submission before your lordship, Manoj, the question does not.
Not difficult, we grant time, but we'll pass an order while granting time.
Please, Manoj.
So that we can recollect the subject matter next time. That's the.
No, I'm sorry, that I can't come in the way.
So, but then nothing shall undergo change.
No, Manoj, I'm making a statement before your lordship. One other, just to explain to your lordship, Manoj, your lordship may, just for, we have read that order, page 72 may be kindly seen, Manoj.
Yes.
Just before the thing, Manoj, this order is issued based on the approval on, my lord, page 72, after condition number 1, 2, and 3, my lord.
Yes.
Below, right below, the order is issued based on the approval given on the cabinet committee's case number so and so. The cabinet has taken a decision with regard to allotment of this land in question, my lord. The matter was placed before the cabinet, a proposal has come. The question is this, what my learned friend is trying to say is, if it is a corporation property, my lord, it cannot be given at all. I'll be able to place before, my lord, in identical circumstances under section 176(6). Your lordship may kindly turn to page 72, second line, my lord. As per the Karnataka Municipal Corporation Act 176(6), it is.
No, I'm sorry, I was saying something.
As per the Karnataka Municipal Corporation Act 176(6), it is necessary to get the prior approval of the government before selling but leasing the corporation.
What is 176?
Vote of. So the question is whether the state government has the power to pass an order under this. That's the short point.
Power to grant the land in this way.
Yes, yes.
Their power is.
There or not is the sure.
Traceable under.
Yes, yes. I brought on to you.
So therefore, my lords, 176 subclause 6, nothing, notwithstanding anything contained in this act, my lord, I'll skip A, B, Roman 3, my lords. No immovable property, 6B3, no immovable property shall be disposed of by dispose of sale or by or other transfer, except with the previous sanction of the government. So therefore, my lord, the statutory gives the power of the state government to dispose of the property by any other transfer. So this has been interpreted by the court, my lord, saying that the power of the state is there. So therefore, there's no limitation on the right of the power. And I'll be able to place, my lords, just for your lordship's thing, with the exercise of powers previously, my lord. Now, what has happened is, my lords, the corporation of Hubli Dharwad, it's a political between saying that between the opposition party without naming the political parties. So therefore, in the garb of PL, they're saying that because it is given one political party, I'll place before all the lordship which and all political party same resolution under which whom and all has been given. So therefore, my lord, we'll file an objection. I made a statement before your lordships, my lord, that nothing will precipitate till then, my lord. So therefore, your lordship may kindly consider this aspect of the matter.
So 8, 7, 8, 9. Of 25. Third learned senior advocate Mr. Dhyan Chinnappa, assisted by learned advocate Mr. So and so for the petitioners. The two petitioners herein asserts themselves to be in public life and are the elected corporators. Wherever the present petition is filed, a prayer to set aside the order, set aside the government order, dated 27/2/25, whereby and CTS number 4553/B, situated at ward number 1 of Ubbali, HUBBALLI, at measuring 2988.29 square meters. It is already granted.
Yes, ma'am.
Is granted.
Yes, ma'am. That is why I said, my lord,
Purpose of construction of.
no, that's why I made a submission, my lords. Between the grant and till we filing, we will not precipitate it so that no further thing.
The transaction, Lord, has to happen from the corporation to the party. This is a sanction under 176(6).
Correct.
Sanction, not a grant.
Thank you, sir. Yes, sir.
Is considered to be granted.
No, sanction. They say it is sanctioned under 176(6).
Thereby, sanction is granted. Sanction is accorded. To grant. Sanction to grant.
No more. Sanction is accorded for
the word, on the basis of the proposal of the so and so, land for the construction of so and so is being considered a special case.
Correct, my lord. Page 72, on the basis of the proposal so and so.
Transaction has to happen.
It is being considered and so on is ordered or has already been ordered, my lords, to be grant. This is an order of grant.
It's an order of grant.
Yes, my lord. Your lordship may kindly.
That is what. The said order is an order of grant, whereby the said land is granted for construction
That's
of.
the consequential thing. Okay, we won't do that.
A district office building.
One second.
To a political party, considering it to be a special case.
Where did you get that?
Approval is also granted to fix the value of the land at the rate of 5% of the present guidance value on the conditions mentioned in the order. The questioning of the said grant of land to the political party. Thanks. Is questioned by the petitioners on two main planks. The first submission coming forth from learned senior advocate for the petitioner is that the said land which originally belonged to the railways came to be sold to the Hubli-Dharwad Municipal Corporation, and that the land in question is originally classified as reservoir.
It's for a reservoir.
Reservoir land. Full stop. When a query was put by the court as to whether any substantiation is available for the plea that the land belongs to a reservoir, that the land is a reservoir, comma, learned senior advocate submitted that for the present he does not have any documentary substantiation. However, learned Additional Solicitor General of India, Mr. Kamath, who appeared on behalf of respondent number
Second respondent.
Railways,
Railway department. Railways, madam.
two,
Two.
Southwestern Railways. It before the court that if the time is granted, he would the above aspect. In addition to the above aspect,
We seem to be very happy.
the section is that the land in question is by way of the impudent regard of the policy. Framed by the government. Policy guidelines framed by the government in relation to the disposing of the lands belonging to urban and local bodies. Full stop. Government order dated UDD 129 TMD 2002, Bangalore, dated 26 2003. Figures on record into bracket annexure E. The said order is also referred to as one of the basis for also referred to as one of the consideration gone into while passing the impugned order of grant. Noticing from the said government order dated 2/3/23. The categories of LOTs are identified and it is contemplated as to at what rate of market value the land belonging to the urban local bodies could be considered for grant to such individuals, institutions, and non-religious societies, etc. certain categories such as schools, colleges, hostels, Anganwadis are enlisted for free allotment, comma. The other group of entities are considered for 25% of the market value or 55 or 50% of the market value, as the case may be. Full stop. The paragraph, the institutions, public individuals, and non-religious societies which are not approved by the government or not registered under the Income Tax Act 1961 are to be allotted, if to be allotted, would be given the land on market value. It was the case and contents on petitioners that the grantee body in the present case could not have been granted the land at a concessional rate, which would amount to giving the land on throwaway prices, throwaway price, full stop. Furthermore, from the impugned order, from the order impugned dated 27/2/25, from the contents of the order impugned dated 27/2/25, certain aspects would be figured out, which are undisputed. Full stop. Firstly, the proposed property belongs to the municipal corporation. Secondly, it is stated that as per the government guidelines, such properties can be disposed of only by a public auction and could be allotted through process of public auction. It is stated that the proposed grant is not approved by the municipal council. It is further stated that the Honorable District Minister, Dharwad District, requested to hand over the property for the construction of an office building for a political party. Full stop. It was contended paragraph that despite the above aspects surfacing on facts, the land is granted under perpetual exercise of section 176 of the Karnataka Municipal Act 1976. As noted above, the purpose of grant is to facilitate a building considered to be granted for value at a rate of 5% of the guidance value. There will be no gainsaying. The land in question, which is made subject matter of grant for the above purpose in the above manner, is a public property. For a public property, it is settled law that there cannot be a larceny or bartering it away. Full stop. The normal rule of auction would apply, as was rightly submitted by learned advocate for the learned senior petitioner, and is rightly reflected in the government guidelines also, as well as the rightly reflected in the impugned order and the guidelines.
With your lordships, kindly,
Guidelines.
both, I'm sorry, your lordship, can I make, the cabinet decision and the guidelines are on the same day, my lords. Your lordship can see both are on 20th February 2025. So
2003, they are 2003 guidelines.
no, subsequently, my
At
lordship.
this stage, learned advocate general invited attendance. 2003.
This is 2025.
Invited written report that the
No,
decision. is
Your
level
Lordship,
three.
this is 6 June 2003, the paragraph 72 saying that 20th February 2025, cabinet takes note of this, my lords, and then they refer to all these facts are stated as it is, my lord. The question is,
Learned Advocate General, Mr. Shashikaran Sethi, who appears also upon service.
my only request, my lords, is
In advance on behalf of the respondents.
my humble request, my lords,
Submitted.
that if a finding is given at this stage,
We are not recording any finding.
that's all, my lord.
We'll
Because,
make it clear.
Your Lordship,
We'll make it clear that these are not the findings. Invited in report that all aspects, including guidelines, were taken to consideration by the cabinet, which approved the decision for grant. Full stop. Having noticed all the aforesaid prima facie aspects emerging from the controversy, although without concluding anything finally, the court is inclined to issue notice and also inclined to require the parties to maintain status quo so that the subject matter is not precipitated during the pendency of this public interest petition. Full stop. As the petitioners are in public life and corporators, their locus standi could hardly be questioned. Full stop. However, the court is persuaded, paragraph. However, the court is persuaded not to pass an interim order, since Learned Advocate General prayed for time to file a reply and further made a statement before the court that what
no,
We will not precipitate the matter. any
no,
further.
we will not precipitate the matter till the matter is, till the next date of hearing.
that the status quo will be maintained and no
Please,
Precipitate.
Your Lordship, Your Lordship may refer status quo will be maintained.
the language of law, it is synonymous.
Ultimately boils down to the same thing, my lords.
Will not put any words in your mouth. Whatever you say will record.
We will not precipitate the matter till the next date of hearing.
So you are satisfied.
Yes, my lord. If my learned friend says so, I'll take it.
The subject matter shall not be precipitated in any way during the pendency of the petition.
Very good.
Can I make it till,
Notice returnable on.
can I make it till next date of hearing, my lords?
Notice shall be returnable on which date?
Or I think the corporation also is before the court.
Only the fourth respondent.
Only fourth respondent
notice
application.
will have to go.
All others are before the court.
Whether,
1, 2, and 3 are before the court, my lord.
since rest of the parties, respondents are represented by learned advocates who accept the notice, there shall be notice to be served. Therefore, notice returnable on so and so, which date?
Any date, your lordship may have it.
9th of April,
9th of April.
or
Well,
21st of April,
April,
21st.
21st of April.
Little longer, 21st is,
21st of April. Full stop.
yes.
All the respondents except respondent 4 are represented by learned advocates. They accept notice on behalf of respective respondents. Respondent 4 shall be served.
I'm grateful.
Number 10, blood on the petition. But this is a case, blood, where the petitioner is placed in a very unfortunate situation, blood. In the sense, blood, the petitioner was granted lease to extract the ordinary sand, blood. subsequent to the blood as a grant, a barrage was constructed for the purpose of diverting the land to Davangere city for the purpose of drinking. Water storage was there. My entire land blood granted for lease was covered by water. I was not in a position to blood extract any land at all, sand at all. But under those circumstances, blood, I made a representation to the government repeatedly saying that there is an alternative land. Blood, the petitioner belongs to blood scheduled tribe, under which category only blood the petitioner was granted the lease. Now the blood, there is a land, alternative land. So that was granted to the scheduled tribe category person. Blood, that land is also available. Blood, I made a request saying that blood, this is the situation in which you have constructed the barrage, which has caused great loss to me. Therefore, grant me the alternative land. Blood, that is being rejected by the concerned authorities. Blood, this honorable court on an earlier occasion on 6/7/2023 on annexure P blood, page 231. When I came before this honorable court in the second round of the writ petition, blood, this honorable court directed the government to consider my request, blood, in the order passed by this honorable court, blood, except saying that grant the alternative land to the petitioner. Every direction was given in my favor. You last me kindly see. Directions only. I am referring to the directions issued by this honorable court. At page blood through 238 is the earlier order of this honorable court.
So you want alternative land?
Pardon?
You want alternative land
Yes, blood, we want. It is available.
for mining?
Yes, for extracting the ordinary sand.
So this has gone in some riverbed?
Yes, my lord. It's, my lord, backwaters of the dam, my lord, because of the construction of a barrage, my lord, the water has been stored.
So dam was constructed subsequently?
And
No,
there is
there
no
was a
dispute
barrage
with regard to that.
constructed.
Subsequently?
Yes, sir, subsequently.
There is some provision you are telling?
Yes, sir, yes,
My
blood.
lord, there
Alternative
is,
grant.
The rule 56, blood.
We had considered some matter. You yourself said that I'll consider.
no.
This order said there is no provision.
Yes, let them consider, blood. Let them consider.
Let us see what is
Yeah,
what
yeah,
rule 56.
great.
If the factum of that dam and the construction thereof subsequent to the grant of lease
Subsequent to the grant of lease,
is not in dispute, then you should consider.
there is no dispute.
And if there is a provision.
Yes.
152.
Rule 56, this was not taken into consideration at all. May I read? Blood? Relaxation of rules in special cases. In case where the state government is of the opinion that the public interest so requires, it may authorize the grant of quarrying lease or license for quarrying or reserve any land on such terms and conditions other than those prescribed in these rules, as the state government may by order specify. Blood. Notwithstanding anything contained in these rules, such safeguards, territorial, financial, or otherwise may be provided to the lessee or licensees with a view to safeguard the interest of any industry or trade in order to avoid unhealthy competition among the lessees and licensees, and to prevent, you last me kindly mark this, blood, and to prevent any fall in the trade, and to see that the minor mineral is exploited in a scientific and systematic manner.
This is not for alternative.
This has not been considered at all.
No, this is.
No, this is not for alternate land. There is no provision my lord, to grant alternate land.
When hardship has been caused to me at the instance of the authorities.
So this rule will operate in which cases?
My lord, that was a case that was submitted by the learned senior counsel, Srimati Anuradha. My lord, wherein, my lord, her land had been acquired and now she was seeking for 9 acres of land and she had quoted this rule. And my lord rightly observed, when there is no provision, my lord, the government can take a call on that. But when there is no provision.
Take a call, but this directly doesn't entitle.
No, 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 no.
Yes. Where is the colon? Fall in trade. So how do you compensate them?
My lord, that I'll have to seek instruction.
No. Compensate them for the loss. due
Loss
to-
caused to me, my lord.
For the loss caused to a validly held quarry lease because of construction of land. And one of the mode is to grant alternative.
Yes, my lord, I'll seek instruction.
Because the dam was constructed during the substance.
Yes, during the subsistence of the lease.
My lord, but the problem is there is no provision to grant them alternate land. Anyway, I'll have a discussion, my lord. My lord may grant me some time.
We can dispose of this, requiring to invoke rule 56 and consider the request for alternative land. It will do.
Yes, that is our request.
My lord, could.
If you are taking a decision on your own, we are making it very clear what we are thinking. If you are taking decision on your own in their favor, well and good. But even if you are to take a stand that this rule will not apply for grant of alternate land in such circumstances, we will say that one of the mode to compensate to the leaseholder for fall in trade, which is again due to not on account of the circumstances within his control. The alternative land can be granted.
My lord can grant me some time. I'll put it across to the government.
Will grant some.
Doesn't. But this is nothing but my lord giving in one hand and taking in the another. Subsequently, they have prevented virtually.
Rule contemplates relaxation. It says special cases and fall in trade. Then
My lord, but that should be in public interest, my
To
lord.
safeguard the interest of the industry.
Public interest, the
safeguard the
industry.
interest general, yes. Find out.
My lord, maybe.
Find out, is there any precedents where such alternative grants, in such cases, lands are granted?
No, as my lord has rightly put it across. How do we compensate them? Because the barrage was constructed after the, my lord, license was granted.
Such safeguards, territorial, financial, or otherwise may be provided. So it is territorial safeguard. It may include giving of alternative land. It
My
may
lord, the
also-
rule is, my lord, the first rule 1. In case where the state government is of the opinion that public interest so requires.
It may authorize the grant of quarrying lease or license or so on, so on, so.
If public interest so requires.
In any, we perceive that this rule can be invoked in there.
Oh, my lord, I'll put it across. I'll see how it can be worked out.
And what happened to the other matter?
My lord, the other matter I've written to the government, my lord, but there is no provision to provide alternate land. Because if my lord, if we grant in one, it will set a precedent.
Then if you are not able to take instruction in that matter favorably, what instruction?
My lord, no. I have just put it across. My lord, preliminary discussion is that it will set a precedent in practically, my lord, many matters.
Highlighting the facts pleaded in the present petition and the prayer made in that context from a learned senior advocate, so and so, so and so. 6. Benefit of Rule 56 of the Karnataka Minor Mineral Concession Rules 1994 to submit that since the co-release of the petitioner during its subsistence went into the area of dam constructed, the petitioners would be compensated by offering any alternative lease. Full stop. Notice returnable on 22nd April. Learned additional government advocate states that civil instructions.
My request is, my lord, in the memo, let them not precipitate to recover the royalty.
Lord, order is
We are
of
not
the.
expecting.
that
What
when-
precipitation?
Like they are demanding higher royalty, though I am not
Lord, order
expecting
is
any
of the
kind
year
of-
He can't say that they
2023.
should not release the. What is, it is already precipitated. Therefore, you are here. Take the next steps notice and states that that he shall take instructions.
I'll seek instruction.
Looking to the compass of the controversy. There you go. Prima facie noticed. The petition shall be listed at 2:30.
Lord, not at 2:30, my lord.
Yes.
At the regular, my lord. Regularly, not
No,
at
we have
2:30.
made our mind open, subject to, of course, what you say.
My lord, but my lord, I agree with my lord, but I have to get my lord instructions in writing from the government to
All
make a
right.
submission.
Not
my
at
lord.
2:30. Do you remind us if reply is filed? Great.
Obliged, my lord.
So number 11, Mr. Viresh K.
Petitioners are the milords, residents of Siggaon milords, town milords. Where milords, the respondent number 6 to 9 milords, who are the private respondents milords, are running milords, sawmill industry milords, and causing voice pollution in the heavy noise pollution in the.
Notice returnable on.
Milords, there is an interim prayer, milords, in the regard, milords. Because, milords, there is a report from the environmental officer, milords, saying that, yes, there is a noise pollution, milords, and also they have directed the town municipal council, milords, to take action against them, milords, or at least.
Advocate Mr. So and so for the petition. So notice returnable on 24th of April. Learned additional government advocate Srimati Nilofer Akbar as well as learned advocate
A. Mahesh Chaudhary. For A. Mahesh Chaudhary.
Mahesh Chaudhary. And learned member, he is there in the court. He is not there in the court. Then how can we waive?
Rashi for A. Mahesh Chaudhary.
No, Mr. Mahesh Chaudhary is in the within the premises of the court.
No, Your Lordship, I'm taking on behalf of A. Mahesh Chaudhary.
Then how can he waive when he is not present?
He's he's online, Your Lordship. There's some inconvenience.
You waive, you can waive.
Please, Your
And
Lordship.
learned advocate Ms. So and so appearing for learned advocate Mahesh Chaudhary. Waives notice, accepts notice on state and control board respect.
Interim prayer, milords, because
Before the next date, reply shall be filed.
the interim prayer, milords,
Learned advocate for the petition presses for interim leave. The interim leave cannot be granted for the simple reason that granting of any relief in any form at this stage will amount to allowing the petition. It is right principle that at the interim stage, the relief in the nature of grant of principal relief cannot be granted. Therefore, the prayer is refused. You want those lines?
Please.
Only 5, yes.
Great.
So number 12, Mr. Ravindra Gajanan Pillai.
Here for petition, my lord. I request a week's accommodation, my lord. Senior is out of station, my lord.
Yes.
I request weeks. Senior is out of station. I request a week's time, my lord.
It will go then 18th of June at the request of learned petition on the ground that learned senior counsel who is to conduct the petition is out of station. Next.
The writ appeal matter, so still number 13. Mr. Ramurthy B.
Delay of 40 days. Notice returnable on 23rd June. Next.
So number 14, Mr. Anil Kumar B.
Wait.
So number 13. Still number 13, Mr. Ramurthy.
निकल गए लाइव ये होता है Yes, polymetric 2/3. Polymetric.
Mr. Anil Kumar B.
I appear for the appellant members. There's a
Delay.
98 days delay.
So notice returnable on 19th of June.
15 is urgent. Number 16. Mr. Sharath Kumar G. Number 16.
Respondents, my lords.
Well, submission, my lordship, the senior counsel was engaged, Mr. Wadhayola is in another court, madam. Can you have any date maybe? Convenient.
Serial number?
16, madam.
16. Any urgency?
Please.
What is the urgency?
Not.
What is the urgency? We can keep it after some time.
Please.
Beyond vacation.
Next month, maybe any date. Next month, any date. Maybe.
Next month, learned advocate, the appellant stated that the appeal may be put up. As request. Yes.
Number 17.
17 deal returnable on permit of service. Copy of the application may also be served to learned advocate who appeared before learned.
In the contempt petition.
In the contempt petition, who appears in the contempt petition.
Obliged.
Contempt petition will also be listed on the next date, along with the writ appeal and the delay.
It is listed today, my lords.
What about 18?
17.1, my lords. Condition. They have filed the writ petition post my filing of my contempt petition, my lords. It's a delay of 122 days and they have not complied the order of the Honorable Single Bench Law Order, my lords.
Pardon?
They have filed the writ appeal post filing of my contempt petition, my lords, only to precipitate the matter.
Number 18. Mr. Shailesh.
That part is no nexus, yes.
There's a delay.
Delay for grant. You are in 18?
18, I appear for the appellant. There's a delay of 15 days, my lord.
Leave to appeal application.
Lord?
The application for leave to appeal.
Yes, my lord.
Leave to appeal.
Yes, my lord, leave to appeal. Because I was not a party, that's my main contention. I was not a party in the appeal. What has happened is, a writ petition came to be filed against which an order was passed in favor of the third respondent without making me a party. I'm the original complainant. My case is this, my lord. Originally, the land which has been now the concerned land, which is now in the custody of the government, was a Kharab land, which is a government land. There are records up to the year 2018, which show that it's a government land. Later on, it is shown as not a government land,
So
based on which
what was the prayer of the petitioner in the petition?
the prayer in the writ petition.
See
your
the
lordship
application
can
under
say.
section 122.
Yes, my lord.
What is that application? For conversion?
Yes, my lord. Their contention.
No.
Yes, my lord.
What is this application under section 122B of the land, Karnataka land revenue?
Yes, my lord. That application
For what?
is for making the payment of money for conversion of this land. For this land.
Conversion.
Yes, my lord. An application was filed. One moment. I got the act itself. My lord. One moment. An application was filed.
Now, who are you?
I'm a local resident of the village in which the particular property is situated, my lord. I made a complaint saying that this particular land, which is basically a government land, because there is a hillock. There are records to show, which I have produced before this honorable court, to show that these are all lands which belong to the government. Subsequently, in 2018, the character of the land has been changed from a government land to a big Kharab land, which means the government, it could be a private land. Based on that, an application is made by the petitioner, by the third respondent, claiming that this land, that's the ground that they have made, if your lordship sees, at page 25, my lord. This is what they have said. In the ground number 9, it is submitted since the first respondent state government was having issued direction order dated 16/5/2018 for classification of Kharab land as A and B, and petitioner's land being listed under A Kharab. The direction order dated 16/5/2018, the issuance of notice by respondent is contrary to the said direction. It is submitted now the petition having approached the DC under section 122B of the Karnataka Land Revenue Act.
Harish,
Please, my lord.
if the order is passed by competent authority
Please,
in relation to that 122 application of the petitioner,
please,
suppose conversion is granted
please.
to the petitioner, original petitioner, then that order is appealable.
For appealable.
Appealable. Yes.
My lord, no, because I was not a party.
You don't have interest in that sense.
My lord, with those observations, that I could make an necessary appeal, the appeal matter could be disposed.
If section permits, then we'll.
Conversion order. ಇದು ತಹಸೀಲ್ದಾರ್ order. Conversion order.
An appeal shall lie by whom it is not.
136. Section 136 provides for an appeal.
Section.
But it does not say in so far as anything in respect of section 122, madam.
So you have the right to be heard in 122B proceedings.
Please.
As per proviso to subsection 1.
My lord, there is an appeal provision. If your lordship turns to section 9, appeals from original orders.
Correct.
There it says, if such an order is passed by the deputy commissioner to the tribunal or the assistant commissioner, appeal is provided. The question really is whether such an appeal is open to me.
Even before appeal, you go to 122B proviso.
Millard. My lord, any person, if your lordship sees, any person aggrieved by any order of the deputy commissioner.
Not that, proviso. Proviso. Before that. Provided that
no order prejudicial to the occupant shall be made under this subsection unless the applicant or any other person interested has been given a reasonable opportunity of being heard.
You or any other person interested.
I understand. May I request your lordship to have it tomorrow, my lord? I'll see whether we could leave seeking a withdrawal of the appeal itself.
Tomorrow at 2:30.
Please, my lord.
Tomorrow at 2. Thank you.
Proceedings.
Bill number 19, appeal by the state.
There's a delay of
Notice.
7 days.
Caveat respondent. We'll be filing our objections, my lord, so far as the delay application.
Notice returnable on.
We request, my lords, request that sometime next month, because the matter lingering from 1990.
16th April.
Please,
16th April, yes.
very well.
If any reply is to be filed to the delay condemnation.
Or if they have no objection to condone the
No, no, no.
delay.
We are filing
then I'll
objections
make my
to the delay.
submissions on.
We would have condoned, but Mr.
Yes, no, they
Phanindra
want
said
to file it. There's 1 year delay. Every time there seems to be a delay, every time, my lord, that's why we want to file it.
Learned senior advocate Mr. Phanindra stated, who accepts notice on behalf of his.
Caveator respondent number
We have
2.
the caveator.
Please,
That he will file
Shahbaz, Mr. Shahbaz Hussain takes.
a reply to, reply seeking to oppose the
Private
contract.
respondent. All the, let's, we will be taking notice for all the private respondents.
Appears on caveat and accepts notice on behalf of all the private respondents, comma. Submitted that he will file reply opposing the condonation of delay. Seeking to oppose the contract. For the next date.
Number 20. Kalesh Aji.
Two days delay is there.
Your original,
I will grant LRs of the grantee, my lord. In the petition, in writ petition number 23-637.
your
Other writ appeals are pending on against the petition 13.
Alesha,
Please, my lord.
and your party in the writ petition.
My lord, party is my lord Akkayappa. The page 20, my lord. In writ petition, my lord. Please, my lord.
You are a party in the original proceedings.
Please, my lord.
Which party? Dispone number?
My lord,
Were you a party in the writ petition before?
Please,
learned
please,
single-
my lord, please.
So which
My
respondent?
lord, page 20, the cast title of the writ petition.
You are the petitioner, man.
Petitioner in Akkayappa Venkatesh.
You are the petitioner
Writ
before the
petition, my lord, 23-637 of 2012.
Where are you? Your name is Alesha. No, sorry. What is your name? Akayappa.
Akkayappa,
So you are the petitioner.
petition.
Yes, what is the matter now?
That is a matter is issued land under the PTCL Act, my lord. But the learned CC before the learned single judge, my lord. The grant is in the year 1930. My lord, for the financial assistance document has been executed in 1950, my lord. Original sales taken place in 1973. Immediately within a year, my lord, the presumption application has been made as per the Supreme Court judgment, also within the limitation. But my lord, for the financial assistance we have executed 1953, that is not a sale, my lord. My lord, that is only to prove that, my lord, no doubt that deed has been given effect to the revenue documents before the revenue authority. Annexure C, and also it has been very clearly mentioned in the that this document, my lord. No document, original document has been handed over to the purchaser. And my lord, all possession is with the grantee. And my lord, all revenue documents is continued with the original grantee, my lord. Therefore, my lord, the first sale is 1973. That was not considered by the learned single. And also, my lord, against the other writ petition, my lord, another writ appeal is pending before this. Writ appeal
Sorry.
18490.
Now they want to repurchase. Okay. Now you are seeking regrant, restoration,
Assumption of land.
and that is rejected. That is rejected,
That is rejected.
rightly rejected. What is wrong in it?
My lord, as per my lord, as per a discussion
You,
made.
you sold out the land after grant, then again repurchased, again sold. Now you are seeking
That is
this
the-
all
my lord,
happened before coming into force of the act.
My lord, 1950, my lord, the deed executed by only financial assistance, my lord. Therefore, my lord, same party has been returned to the, after receiving the amount of financial, what is he lent to me, he returned to that amount, and therefore, my lord, returned to the land by executing the document.
So see, the moment the purchase was made by the applicants from the purchasers who were entitled to purchase it, the land essentially becomes their personal property and cannot be constituted as property of the grantee. So there is no question of restoration.
My lord, the
Having
and also, my lord, another writ appeal is pending against.
and the conveyance was not hit by any prohibition.
Prohibitions.
Prohibition.
No prohibition. Another writ, same grant, my lord, in respect of grant, my lord, another writ appeal is
Sorry.
pending, my lord.
Dismissed. Nothing, there is
My
nothing.
lord,
We'll say that
my lord, engage the same senior counsel, my lord, in the same grant, my lord. Same
After-
grant, writ appeal is, notice has been ordered by the honorable court, my lord. Writ appeal 1849 of 2024, my lord.
while the present heard learned advocate Mr. Alesha Arju for the appellant dash applicant and learned additional government advocate Mr. Harish upon service of copy of the appeal in advance. Full stop. While the appeal comes up on board along with the interim application for condonation below 32 days. Full stop. Since the papers of the main appeal as well as the order of learned single judge impugned in the appeal was available on
Well, I
record.
may
for-
provide an opportunity to engage the senior counsel, my lord. My lord, same grant, my lord, is another writ appeal is, my lord, notice has been ordered. My lord. Writ appeal is pending before the honorable court. Same against the another connected writ petition, same common order has been kindly similar. Writ petition, my lord, 13/8/0806, my lord. Against that writ appeal has been paid with before this honorable court has been ordered the notice, my lord. Writ appeal, my lord, 1849 of 2024, my lord.
Yes. Comma. And the submissions were made by learned counsel.
Well, sale deed, my lord,
The court-
executed by that document is not a nominal sale deed, that judgment is there, my lord.
Had an occasion to delve into the merits of the challenge itself. Full stop. The
It may be taken along with that
Appellant
writ appeal,
petitioner,
my lord, pending.
Right.
This writ appeal may be lodged.
To set aside the impugned order stated 26/5/12 passed by the Deputy Commissioner, Dispensed number 1 hearing, as well as the order of the Assistant Commissioner dated 2/8/2008, which was confirmed by the Deputy Commissioner. Full stop. The facts were that an application was filed by one Shardamma, wife of Chennappa, who happened to be the daughter-in-law of the original grantee of the land. Described as survey number 93/4 at measuring 2 acres situated at Thani Sadra, THANI SADRA village, Krishna Rajapuram, Bangalore East Taluka. The prayer was made before the Assistant Commissioner by filing an application for restoration of the land on the ground that the applicant was the heir of the original grantee. The prayer for resumption came to be rejected by the Assistant Commissioner, and the Deputy Commissioner in turn dismissing the appeal, confirm the order of the Assistant Commissioner. It was those orders which came to be challenged before a single judge. Paragraph. The relevant facts to be noted are that said land was granted to Chennarayappa in the year 1930-31. As per the rules prevalent at the time of grant, there was a condition of not alienate, condition prohibiting alienation of the land for 20 years. Full stop. The original grantee sold the land after the embargo period of 20 years on 3/8/1953. When the land was sold, thus, the sale was permissible as per the condition of the grant. Paragraph. It appears that subsequently,
Page 49 of the writ appeal kindly.
in the year 1974, the grantee decided to get the deed of reconveyance executed in the name of his first wife's supposed to be a son.
Page 49 of the writ appeal.
A stand was taken, paragraph thereafter, that the earlier the stand was taken by the applicants as the grantees, heirs of the grantee, that the original alienation of the land was not permissible in law as it attracted the bar of the provisions of the Karnataka scheduled caste and scheduled tribes into break prohibition of transfer of certain lands over Act 1978. More particularly, Section 4(2) of the said Act. Full stop. It was on that count that it was on that ground that application was made before the Assistant Commissioner for restoration of the land. However, the same was held not liable to be considered by the Assistant Commissioner, and the rejection was confirmed by the Deputy Commissioner, as stated above. Learned single judge.
Page 49, my lord. Annexure C, my lord.
Observed that once the sale deed was executed, there was a transfer of title validly made in favor of the third party named Chennarayappa. Paragraph, not paragraph, learned single judge reasoned thus, extracting from paragraph 20, then quote paragraph 20, page 28. It was then observed by learned single judge that the moment a purchase was made by the applicants from the purchasers who were entitled to purchase it, the land essentially became their personal property and cannot be construed as property of the grantee, Chennarayappa. Consequently, the sale made by them in the year 1992 cannot be held to be a transfer in contravention of the term of the grant. Full stop.
My lord, sorry for it, my lord. That reason is not
The said reasons
without considering the annexure C, my lord.
dismissed the petition and upheld the orders of the Deputy Commissioner and the Assistant Commissioner. Full stop. The view taken by learned single judge in the facts of the case could be said to be eminently proper and legal. No interference would have warranted in the impugned order. In that view, the question of condoning delay does not arise. In that view, the court is not inclined to. In that view, the question of condoning delay does not arise. It is not condoned. The application for condonation delay as well as the writ appeal both are dismissed.
Number 21.
Lord, the owner of the property is before your lordships, Lord. In a municipal tax assessment, Lord, there are two writ petitions, Lord, which were filed different points of time. This item and the next item, Lord. In WA 406, which is now before your lordships, Lord, it arises from writ petition 43952. Lord, what happened in this case, Lord, was for the period 2008 to 2017, there was a demand notice that was issued at Annexure G, page 127. The English version of the notice is at page 127. This was not preceded by any order of assessment. Now, please notice this date is 12/7/16 and the period is 2008-9 up to 17-18. Now, my lord, for 2008-9, there were things that they had instituted which had, my lord, ended in an appeal before the district court.
All the petitions in a single are identical.
Learned single judge, my lord, did not consider anything, my lord. All that he said.
All the petitions were identical.
All the
petitions which were
yes,
held.
both are petitions, my lord. The only difference is this, my lord. In the companion petition, that is 38112, what was in issue, my lord, was for 2 years, 2008-9 and 9-10. Now, my lord, the proceeding was instituted by a notice. No order of assessment was made. No determination was made. Straight away, a demand notice is issued. If your lordships would please go to page 127. The question, my lord, is, I am a software company. What is the correct head of assessment for me is a question, my lord. They straight away demand tax at the higher rate. Then, my lord, they say double the amount of tax as penalty plus the interest. Now, my lord, I raised number of contentions, including one of limitation, because section 108A, my lord, talks of limitation within which period they can make the demand. None of those are considered. The learned single judge, my lord, is impressed by the fact that on the merits of this classification, there is a judgment of the learned single judge which holds that my contention is not tenable. That is in appeal, and the appeal has been admitted, and there is an interim order granted in the appeal also.
Appeal against order in 56279.
Yes, my lord. 1528 of 16 is the writ appeal number. In fact, my lord, I later realized that the learned judge was sitting in the division bench also. Now, my lord, the submission I'm making is this: without notice, without assessment.
But if the interim stay is granted in appeal, then
in that case, there's been interim stay. My lord, what has happened in this case is I have paid, my lord, if your lordship permits, my lord, after this writ appeal was filed, they came to my premises, threatened me to say we're going to lock it and seal it. And under coercion and duress, my lord, they recovered a payment from me for 12 crores 94 lakhs. So out of 19 crores, may I file the memo, my lord, with the letter for payment?
you have paid.
Yes, I paid, my lord.
As per rupees 8.
12 crore. The total demand now, latest demand made after the writ petition was disposed of was 19.61 crores. Against that, I had paid about 10 crores. Now, my lord, they've recovered 12 crore 94 lakhs. So I have totally paid 23.5 crores has been paid. As against, I'm sorry, my lord, 23.50 crores is the demand. I have paid 19.61 crores. In spite of telling them that this writ appeal is been numbered, it is likely to come up before the court.
So we admit this.
So therefore, my lord, your lordships may consider admitting this because that other appeal is admitted, and there could be a stay for the balance.
Balance of?
Balance, my lord, it will be about nearly 3.5 crores. This amount is not only tax, 100% penalty plus interest comes to 23 crores.
Writ petition number 43952 of 16 was one of the petition which was dismissed by a single judge as per his judgment and common judgment and order dated 12th February 2025. Pulls to the challenge paragraph in the said writ petition by the petitioner. Which was considered along with the other similar petitions. Was to the demand notice issued by the Brad Bengaluru Mahanagarpalika individual BBMP, whereby the property of the petitioner came to be treated under category Roman 14 capital, classified to be subjected to tax at the rate of ₹4 per square meter, whereas the BBMP had treated it in category 8 and the tax was calculated at the rate of 8 per square meter. Full stop. The dismissal of the petition by a single judge was based on the main ground that writ petition number 56279 of 15, which was filed by the similarly situated entity demanding the similar notices, was dismissed, and that the tax at the rate of 8 per square meter was upheld. In course of the hearing, learned senior advocate Mr. Nagananda for the appellant undisputedly pointed out that against the decision of learned single judge in the said writ petition number 56279 of 15, writ appeal number 1568 of 16 was filed.
1528 of 16.
1528 of 16 was filed, and that not only the said appeal is admitted by the court, but stay is also granted.
Yes.
Full stop. In the aforesaid view, the present appeal deserves to be admitted. It is accordingly admitted. At this stage, learned senior advocate further stated that the total demand of tax from the BBMP is rupees is every 3 crore. Petitioner has already paid 19.61 crores.
That is tax, penalty and interest, my lord.
Which includes the tax, which includes the amounts toward the tax, penalty and interest. What is this memo?
Memo, my lord, is to place before your lordships the letter under which we paid that last amount, my lord. Last amount was paid during the pendency of the appeal because we didn't state it in the appeal. They came to us after this appeal was filed.
But
this appeal was filed.
Here you are saying that 11 crores are paid, not 19 crores.
No, my lord, I'm giving total 3 payments were made, my lord. After the writ petition was dismissed,
Memo dated, where is that?
the figure which your lordships will get in this memo is 11 crores 75 lakhs. The 2 other payments, my lord, are part of the writ appeal itself. I have pointed out those payments. If your lordships would like to see it, at page 142, I had made a payment of...
The memo is filed in this regard. Memo dated 26/3/25 is also filed in this regard, pointing out inter-alia that a sum of rupees 11, that out of 19.60 crores mentioned above, the sum of rupees 11,75, 09, 350.70, which was 50% of the demanded amount.
It's more than that.
Which is more than 50% demanded amount, was paid on 20th/3/25, whereas the balance amount has already been paid.
Yes, they were paid on 19/8/16.
On 19/8/16.
Rupees 5 crores 86 lakh 87,659. Your lordships will get that figure at page number 142, my lord.
Notice.
At 143.
The
Other payment, my lord, is at 146.
And on 19, same date?
That first one was 19/8/16. The second one was 22/8/16. Amount was 2 crores.
And the rest of the amount has been paid on 19/8/16 and 28/2/16 as reflected from the record. Full stop. In the fact of the case, when the issue is dealt with in the appeal number 1528/16, in which the stay is granted from above of... You are appearing?
Yes,
You are
my lord.
appearing?
File our objection to that.
For
We'll
BBMP.
file our objections.
By of interim relief, there shall be no recovery from the petitioner during the pendency of the appeal for the balance of the amount.
As prayed for in IA1 of 25. In IA1 of 25.
IA1 is granted accordingly and stand disposed.
Please.
After it, learned advocate Ms. So-and-so, who appears for BBMP, did not dispute the factum of the similar appeal having been admitted, appeal number so-and-so 1528/16 having been admitted, and further that the amounts have been paid by the petitioner's demand of tax as above.
IA2, my lord, may also be disposed of because this memo which I now gave your lordships with the letter, that was not part of the original because subsequently, so the office insisted I should file an IA to produce it.
Well, IA separated. IA2
IA2,
will not
my
survive
lord,
in of the
for
above.
permission to produce.
In view of the above.
Please.
Granting for IA2 is disposed of, and the
It's a notice dated 4/3.
I order in IA. Permission is granted to the appellant to produce the letter dated
4/3/25.
4/2/25. IA number 2 of 25 is accordingly disposed.
Now, my lord, there's a small problem. This WA1528 of 16 is placed before a special bench, of which, my lord, the learned single judge is a member. So on the administrative side, your lordships may review that. Because Honorable Justice Sunil Yadav, Sunil Dutt Yadav, and Honorable Justice Sanjay Gowda are members of that appeal. Of course, earlier, my lord, it was before Honorable Chief Justice only. But because of changes on the roster, my lord, it's a special bench. So your lordships may consider, my lord, now, if this is referred along with that, obviously, my lord, some other honorable judge will have to be a member of that bench. That's all.
No, we didn't get. What difference will make?
No, this order is by the learned single judge who will be sitting in appeal there, my lord. The appeal against this order will go before a bench office. His lordship will be a member. So that bench composition, your lordships may have to change. Honorable Justice Sanjay Gowda, who passed the order in this case, my lord,
Which case?
in the matter which is before your lordships now, when this matter is tagged along with that, the bench composition in that special bench, his lordship is a member there. So for that, administratively, your lordships may, my lord, say what is to be done.
Premature when it comes.
That, my lord, otherwise, this matter will not get listed at all because of the disability and that special bench. So on administrative side, your lordships may review it. That's all I'm saying.
We are not saying to be listed with. This is independent.
No, I understand, my lord. At some stage, that appeal it's already, my lord, been pending for 5 years.
Let that stage come. Or
Please.
if you want to, you can apply to the register judicial.
Please, my lord, I'll do. I'm great.
Then something can be done.
I'll do that. Great.
If you are doing that, then please inform.
I will, my lord. Certainly, I will.
What?
Certainly. I will. 22 is identical. Both are common order.
Common order. So amounts, everything.
There's two. It was for a shorter period.
But then common order will do in both the petitions.
Yes. There are no IAs, my lord, in the second case because the demand is covered by the first matter.
So we'll say that writ appeal 22, writ appeal number 41025. This appeal arises out of the common judgment and order of learned single judge as was impugned in writ appeal number 40625. The facts are similar and the issues are identical. In that view, the aforesaid order shall apply to this case, this appeal also. It is admitted to be posted with writ appeal number 40620.
Please.
Interim order granted in writ appeal number 40625 shall also operate in the present case.
Okay.
But 23. Appeal. My lord, there is a delay. That's number 25. Madhukar M. Deshpande.
Lords, I appear for the respondent. I'm being led by Senior Advocate Mr. Dushyant Dave as well as Mr. Sandesh Chauta.
We need a state.
I appear for the respondent, led by Senior Advocates who are
Yes,
DP as well as in person.
I'm appearing in this matter, my lords, for the petitioner.
I appear for the respondent along with Ms. Atrish.
Yes.
My lord, may I begin, my lords?
Please, yes.
Kindly first have a look at section 17 of the PMLA Act.
Now this appeal.
My lords, is it audible?
Is already, yes.
My lords are not audible, my lords. No, on the right page.
We can't hear your lordships.
It's a system problem from there.
Even technology is afraid of Mr. Raju, my lord.
No, no, they're afraid of you. Call our local council and find out what's the problem.
It gets Raju, it gets
Yes.
frozen sometimes from time to time. I don't
This
know why.
might-
I saw it earlier also. I was been on, virtual hearing since more than an hour. Vivek, remove yourself from the screen. No, your name may remain, not your name. Your name is there. આપણે કહેવત છે ને રાજુ, દશેરાના દિવસે
બરાબર છે. કઈ નહીં, 2-2:30 વાગે ચલાવીશું.
Yeah. I'm free, there's no problem.
Yes, Mr. Raj. Now there is connect.
Yes, now your lordship is audible, my lords.
Yeah. Again, it's frozen, Raju.
Yes.
Sir, is
Predicate offense was under which sections?
audible, sir?
Am I audible, my lords, now?
Yes.
I'll give certain facts, my lord, then I will go to the sections.
So
The predicate offense
the appeal
is
is admitted. Now here you are here.
for interim relief, my lords.
We were saying that appeal was admitted last time.
Very well.
Today you are for interim relief.
Yes, my lord.
So what
Now-
interim relief?
Now, my lords, may kindly have a look at the stay application.
Your
Stay application and
application
the,
says that stays.
now look at the order, my lord. This order, where is that order? Operative portion.
It says that please to stay the operation of the order.
Yes, my lord.
Dated 27/1/25.
Yes.
Now the order is divided into three directions.
Three
First is
directions. Yes,
impugned
my lord.
seizure is-
The first direction is
Fourth is
may I kindly have a look at the
four,
direction.
three directions.
My impugned search and seizure conducted the residence of the petitioner on 28th of October 24 to 29th of October 24, and the subsequent statement recorded in 17(1)(f) of the is vitiated on the ground of absence of reason to believe and is hereby declared invalid and illegal. The statement recorded in the 17(1)(f) of PMLA Act is hereby ordered to be retracted. And my impugned summons issued under Section 50 of the PMLA Act dated so and so and various statements recorded under so and so are hereby quashed. Then liberty is reserved with the petitioner to initiate action under 62 of the PMLA 2002 against the officers concerned before the appropriate forum. As far as the last prayer is concerned, my learned friend was fair enough to say that he's not going to press for this prayer at that stage, but at interim stage. Now, my lords, may kindly have a look what would be the effect of this. The first effect is that there are several searches and seizures which are being conducted all over the country by the ED, and including in Karnataka, they're likely to be conducted. That would be affected, and this judgment would be cited, and they would all search and seizures would become useless as far as the ED is concerned. Then in my application, I've shown
number of places where this order has been cited, my lord. That is, my lords, we say, have a look at page 15. In the case of Srimati Parvati versus ED, in the case of Ramesh Kumar K versus ED, that is at page 18. KG Puttagowda versus ED, which is at page 20. Lavanya versus ED at page 23. HP Rakesh versus ED at page 24. And page 26 is Salve Regina Trust. So large number of cases where this order is being cited. Huh? And the reasoning is totally perverse. May I take my lord therefore to the reasoning and show how it is bad, contrary to Supreme Court judgments, my lord.
Page 36, paragraph 20.
Kindly come to my lords. First para 29 of the impugned order at page 36. My lords are having para 29 at page 36, my lords.
Mr. Raju, one second. Only a second, Mr. Raju.
Let us take the PMLA. Then
Section 17.
Yes.
Now kindly have a look at section 17 first, then I'll take my lords to the judgment, my lords.
Like.
May I read, my lord, section 17? Where my lords are having section 17? Where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section. There is no dispute, and the finding is that the officer was authorized and he was above the rank of the deputy director. On the basis of information, kindly note, on the basis of information in his possession. Information need not be material, it is information. It can also be oral information. Has reason to believe. The reason for such belief to be recorded in writing. The reason to believe has been recorded in the present case. There also I don't think there can be any dispute.
Yes.
That any person, it need not be the person whose premise is being searched, that any person has committed an act which constitutes money laundering or is in possession of any proceeds of crime involved in money laundering or is in possession of any records relating to money laundering or is in possession of any property related to crime, then subject to the rules made in this behalf, he may authorize any officer subordinate to him to A, enter and search any building, place, vessel, vehicle or aircraft where he has reason to suspect. Is different from reason to believe. So reason to believe is different to be formed at the first stage that somebody has committed an offense under the PMLA. The second is reason to suspect. So entering and searching any building, place, vessel, vehicle or aircraft where he has reason to suspect that any such records of crime are kept. So suspicion is sufficient if the first opinion is formed based on reason to believe. And that reason to believe must indicate that an offense has been committed based on information.
Your voice is not reaching and getting interrupted.
I'm sorry. Dushyant, is my voice clear?
Yeah, here it is clear, Mr. Raju.
There is some glitch at my lord's end, my lords. Yeah. Am I now clear, my lords?
Don't stay of all these directions.
Yes, madam. Kindly have a look
Your
at the
voice
direction.
is not reaching, unfortunately.
These directions are, as far as those Para 29, my lords, give the directions.
He's back.
A search is declared to be invalid and illegal.
Yes.
Statements recorded are hereby retracted. Now what will happen is, it will have an effect, a cascading effect, in the sense that other accused who are actually accused, if you are relying on this statement, they would say you can't rely on this statement. They would get bail and probably discharged. Therefore, this statement, if it is ordered to be retracted, it is the person concerned can retract it.
The other accused in the very case.
Yes, the other accused may rely on that statement to say that
other
Rukia is
accused
involved.
In the very case. In
Yes.
this case itself.
Yes.
So the apprehension is that this interim order may benefit the other accused.
Other accused
Other
because
accused
the
have already
statement on
obtained
which they
stay based on this judgment.
and they are also, my lords may kindly have a look, they've
Already
actually
obtained
relied
stay.
upon, the other accused have
There is
actually
reference to
relied
this.
upon. And the High Court has stayed. And 2 cases quashed the search and seizure.
No commentary, please.
29, 30.
This one.
Page 36.
Evidence.
He's deviated from the statute.
How many accused are there?
4. In the scheduled predicate
Yes.
offense, there are 4 accused.
4 accused.
Accused number 2 challenged the summons, and the summons have been quashed based on this judgment. I have produced both those judgments.
From the same reason, we believe 15 searches.
And my lord, 15 searches have been conducted.
Prosecution against all accused based on the same statement.
The summons itself has been quashed against accused number 2. Someone who was accused number 2 in the predicate offense, she challenged the summons.
Summons against the other accused as based on.
It need not be accused, even the person who
Other accused.
There are.
Over and above the present respondent.
Yes.
May I
told Mr. Raju the case based on the same set of facts.
Yes, same set of reasoning of the learned judge, my lord. My lord may also appreciate
the
this.
respondent
It not
was not
only
an
affects
accused
the
in the predicate
accused.
offense, but he was someone who passed the order.
Well, this not only
main
affects the
accused in the
accused,
predicate offense
but
have
it
got
affect-
their summons quashed.
Mr. Kamath, just a minute. But it not only affects the accused.
So these directions are in RAM or what? How do you perceive them?
This would be followed.
These are in RAM or
Even if they're not in
other
RAM,
single judges are
this should have
or qua
precedent
this,
value.
Respondent.
This is, yeah, my lord, it would
Is it in
affect
them?
not only the accused, it will affect other persons whom we want. Supposing we find that there is some material lying at somebody else's place, all this will be affected. All our future searches will be affected. Searches which you have conducted will be affected.
You may be right, but at the same time, we will not be able to granting the principal relief. Indirectly,
Yeah,
the whole
alternate
appeal was
alternate
to
prayer
extend
that this may not be treated as a precedent
because
in other
what is
cases.
not to be, what can be used against the others. Both
This-
ways, it cuts both ways.
Therefore, as far as others are concerned, my lord, kindly have a look at the alternative prayer, my lord. Shall not be relied upon by any person in other proceedings. Shall not be treated as a precedent.
This will not prejudice him. This order will not prejudice him. On here. Okay, discuss it.
He's mentioning.
But isn't this still possible? It's a writ court under 226, and it's pronounced upon the law. It is always in rem. The relief may be in persona, but the interpretation of 17 is obviously in rem, and therefore it is being relied upon on other ECIRs. The 220 judgment of 226 applies all over Karnataka. Connection and save.
Now, may I point out two things, Murad? Murad, as far as the judgment of this single judge of the High Court is binding all over the state, it may be in but it applies in rem, my lord, as far as the interpretation of Section 17 is concerned. And my lord, we will be not allowed to use the Section 50 statement which we have to rely upon.
Yes.
We will not be allowed to rely upon Section 50 statement for opposing bail of others. This is contrary to Supreme Court judgments. Even where illegal evidence is obtained, it can still be used. Today, my lord, there is no prejudice caused to him if this order is stayed.
Yes, Mr. What is the?
But today, may I only point out this, my lord?
Yes.
This judgment is in rem in the sense the order of the High Court, single judge will be binding to all other courts and including other coordinate benches as far as interpretation of Section 17 is concerned. And it will have a wide ramification. Number two, my lords, there will be no prejudice caused to him because what has the court said? The search is illegal and invalid. Statement to be retracted, statement is already recorded. Therefore, no prejudice. Then, if the prejudice caused to me is this, if I am in a position to oppose the bail application of somebody else, or if I want to rely on that statement to oppose, I will be prevented. If ultimately the decision comes in my favor, the person would have got bail and he would have got orders. Thirdly, my lords may kindly appreciate that it is a totally perverse order. Reason to believe and reason to believe is already there because the predicate offense has been registered. So first, therefore, the learned judge has confused himself with the first part and the second part. We want the statement. Show that operative portion of the order, trial court order. Trial court order, high court order. Operative portion.
Yes, please.
Now kindly have a look. But reason to believe is the first part of section 17, as I pointed out, that any person has committed an offense. The fact that there is a predicate offense registered clearly justifies the reason to believe that there is a predicate offense which has been committed. Secondly, that if a predicate offense is committed, there is obviously somebody has to be in possession of proceeds of crime or somebody has to be in possession of the record. So first three conditions and all the four conditions are satisfied automatically when there is reason to believe that a predicate offense has been committed. The fact that the predicate offense has been committed is manifest and is writ at large by the fact that the predicate FIR has been registered, which describes the predicate offenses having been committed. The first part is fulfilled by the mere fact that the predicate offense has been registered. Now the second, therefore the reason to believe is only as far as the first part is concerned. Supposing in a given case, FIR is not registered, and the ED, then maybe ED may not be in a position to form that opinion, independent of other information. The forming of an opinion is a fait accompli in a case where a FIR of the predicate offense has been registered. Once that has happened, then the second part clicks in. So, we may authorize any officer to enter and search any building or vehicle where he has reason to suspect that such record of proceeds of crime are kept. So reason to believe is with the first part, the reason to believe is not with the second part. There are only reason to suspect, which has a much lower threshold. And the learned judge, now kindly have a look at page 29 of the impugned order, my lords.
Page 36.
Page 36.
Paragraph 29.
The learned judge says he confuses between the first part and the second part.
Page?
Page 36, para 29.
Para 59.
29.
Para 29, page 36.
Para 29.
Running page will be 84.
Running page 84.
84. PDF page 84. Running for 84. I'm sorry, my lords. Internal page 36. A review of the recorded reason to believe must show that the material available with the director is sufficient to support the conclusion raised. This conclusion must be based on reasonable evidence. Now, where does the learned judge get evidence? It is information. Now, compare it with section 17. It says information. Evidence is different from information. So, first glaring mistake, first part of perversity is the learned judge expects evidence at this stage. Obviously, there can't be any evidence at the stage of search when you're searching for evidence. Search is meant for evidence. Collection of evidence.
So information in the possession need not be supported by any even elementary evidence.
Yes.
The
evidence is, the purpose of a search is to collect. You may have evidence. In a given case, you may have evidence, but that is not a silent one.
Are you not traveling in the main matter?
I have to go in the main matter, show that I have a prima facie case. I have a prima facie very strong case. Therefore, when the learned judge, he puts the cart before the horse.
Yes.
The learned judge has virtually rewritten section 17. It is nobody's case that there is no predicate offense which discloses the commission of a offense of money laundering. And then kindly have a look at my reasons to believe. And look at the nature of who is this person? He is not a stranger to the offense. He is neck deep in the offense, in the commission of the predicate offense with his role. He was commissioner of Muda, who was responsible for allotting these sites illegally. And he personally inspected these sites and personally said that these sites are to be given. May I tell my Lord the nature of the offense? Persons with having influence, very highly influential persons, have been allotted very lucrative plots, 14 plots.
Yes.
Bypassing the rules, circumventing the rules. If your plot is acquired, plot which are to be allotted to you have been acquired in some layout, then you have to be given compensation by giving you plots in the same layout. Instead of that, this is taken as something to give them plots in a very highly lucrative commercial area where plot prices are phenomenally high. Therefore, there's a prima facie case of money laundering is there. The plot itself would form part of proceeds of crime because you influence this commissioner to exercise what is illegal, his powers illegally, and allot plots which are not meant for you, which are very lucrative plots in lieu of plots which are peanuts, which have been given to the, and there's a fraud of 56 crores. And is the commissioner who was involved in this, if he search at his place, the learned judge says illegal search, unheard of in the facts of this case. He is not a stranger to the incident. We have reason to believe that we can find material, reason to suspect. Is that reason to suspect bad, flawed, because we say that he was the person who was involved in it? This is not a case where bail is to be, the parameters of section 19 and 17 are different. And the learned judge relies upon Arvind Kejriwal, which deals with section 19, where the standard is totally different.
What is 19?
19 is arrest. The reason to believe in 19 is different. It should be based on material. Unlike here, it is reason to give reason to be based on information. But that is the first stage. Information is if the ED officer gets information that an FIR is registered disclosing a predicate offense, that is sufficient information for the purpose of reason to believe. That's the end of the matter. You cannot mix up reason to suspect, which is the later part of the section, with reason to believe, which is the first part of the section. 19, my lords, may kindly have 19 is reason to believe, which has been interpreted in. Okay, now kindly have a look at one judgment of Radhika Agrawal, my lords, directly on the point of reason to believe. Though in my case is reason to suspect. Give me that judgment. Radhika Agrawal is my learned para 10 of Radhika Agrawal, my lords, the concurring judgment. Latest judgment of the Supreme Court, my lords. 3 judges. I'm relying on para 10 of the concurring judgment, that is 2025 SCC online SC 449. Now kindly have a look at para 10 of the concurring judgment. Para 10. May I read, my lords?
Para 10 of the concurring judge.
Yes, my lords.
10 से ऊपर 4 लाइन कर लो, 9 भी कर लो, 4 लाइन.
How does it start? The net effect.
Yes, and it hardly needs to be rated, or the other para 9 para starts. However, when the legality of such an arrest.
He's reading.
How does it start?
However, when the legality of such an arrest.
Page 45. He's reading this is
My lords are reading maybe not the concurring judgment, but the later part of the judgment.
Page 45.
Page 45. Page 45 of the SCC.
Justice Vela Trivedi is
Yes,
concurrent.
the
Yes,
page number
Madam.
is on top, not a small number. It's
Correct.
on left-hand side top.
Yes.
Now kindly turn to para 9, my lords. However, when the legality of such an arrest made under the special acts like PMLA, UAPA, Foreign Exchange, Customs Act, GST Acts is challenged, the court should be extremely loath in exercising its power of judicial review. In such cases, exercise of other power should be confined only to see whether the statutory and constitutional safeguards are properly complied with or not, namely to ascertain whether the officer was authorized under this act. In this case, my lord, there is a finding that he was authorized. whether the reason to believe that the person was guilty of the offense under the act was based on material in possession of the authorized officer or not. There under 19 material in possession, whether the arrestee was informed about the grounds of arrest as soon as maybe after the arrest was made. Sufficiency or adequacy of material on the basis of which the belief is formed by the officer, or the correctness of the facts on the basis of such belief is formed to arrest such person could not be a matter of judicial review. It hardly needs to be reiterated that the power of judicial review over the subjective satisfaction or opinion of the statutory authority would have different facets depending on the facts in each case. The criteria or parameter of judicial review over the subjective satisfaction applicable in service-related cases cannot be made applicable to the cases of arrest made under special acts. The scrutiny on subjective opinion or satisfaction of the authorized officer to arrest the person could not be a matter of judicial review, inasmuch as when the arrest is made by the authorized officer on he having been satisfied about the alleged commission of the offence under the special act, the matter would be at a very nascent stage of the investigation or inquiry. The very use of the phrase reason to believe implies that the officer should have found a prima facie opinion or belief on the basis of material in his possession that the person is guilty or has committed the offence under relevant special act. Sufficiency or adequacy of the material on the basis of which such belief is formed by the authorized officer would not be a matter of scrutiny by the courts at such a nascent stage of inquiry and investigation.
Exactly what that is.
This is why exactly as which has been flouted, and the arrest comes at a later stage. Collection of evidence, collection of material, seizure and searches are still a nascent to nascent stage, but if I may use the word. At an earlier stage, you're collecting evidence, you're forming an opinion whether to arrest somebody or not. At that stage, if the courts interfere, the Supreme Court says you cannot do it. And the learned judge uses the phrase of first part to deflect what has been said in the second part. Suspect, of course, my lords may now test whether though the Supreme Court says you can't go into the sufficiency. But in this case, kindly have a look at it. First part is complied because some person has committed offense, predicate offense. Therefore, first part of 17 is complied with because the FIR has been registered. Therefore, there can't be any doubt that reason to believe that an offense of PMLA of the money laundering has been committed is there based on information. That information is the FIR at the end of the matter, as far as the first part is concerned. The second part is after you form that opinion based on reason to believe, which is based again on information, you authorize somebody. That authorization is you suspect. Of course, he was a commissioner of Muda. He was involved in allotting illegal plots. Is it wrong to suspect that we'll find material at his place? It's a totally perverse order.
Then he says for summons also you have to be.
Then he says for summons also you. Then he says summons. Why can't a supposing person premises is not searched? Can I not summon him under 52 gives the statement? The London says no, because the search is illegal. You can't even summon him. Therefore, the statement of 50 is gone. The summonses are quashed. What type of order is this?
Para 54 is contrary to Vijay Madan.
And para 54 is contrary to Vijay Madan Lal. Kindly have a look at para 54.
It says you have to establish that he has committed an offence before he is summoned.
You have to the para 54 says, before you summon, you have to establish that he has committed an offence. Where does this logic is contrary to understanding? It's contrary, not only contrary to Vijay Madan Lal. Kindly have a look at para 54, my lords.
Page 97.
Page 97.
Yes.
Thus, in light of the circumstances of this case, where no prima facie case has been showing that offence has been committed under PMLA, and no increment, that is shown because the FIR is registered, the prima facie material is there, and no increment material has been elicited at the time of search. So if you don't find anything at the search, it is the material to be decided against me. What logic? Many at the Supreme Court has held in income tax matters that if you don't find anything in the search, that search doesn't become illegal. The person may be deft at hiding things.
Thank you,
That is income tax was a set, brothers. But kindly have a look. No increment has been elicited time of search, and Caesar, the issue of summons petition lacks legal authority. Can I not call him and say, where have you put the material? And ask him question under section 50. So if I don't find something in a person's place during search, I can't call him for investigation for recording his statement under 50. Totally perverse order. Witnesses cannot be compelled to appear and record their statement of produced documents, and such actions would unjustly infringe on personal right to liberty. Now, kindly have a look at section 50, whether there's a prerequisite that he has to be an accused, there has to be an offense. He can be a witness under section 50. That if there is a search and nothing is found at his place, he can't be called as a witness. How can this order stand even for a minute?
Even a search person can be witness.
Even a search person can be witness. But kindly have a look at section 50.
Yes.
You are shutting out. Supreme Court has said in large number of cases that investigation, the prerogative of the investigating agency, court should not interfere. Right from JSC Sultana Justice D.A. Desai's judgment, famous judgment. Powers of authorities regarding summons, production of documents, and to give evidence. The director shall, for the purpose of section 13, have the same powers as the vested in civil court. We are not concerned with subsection 1, we are concerned with subsection 2, because that pertains to section 13, which are reporting agencies. We are not concerned with section 51. Then subsection 2. Director, additional director, joint director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce a record during the course of investigation or proceedings under this act, merely because some search, which according to the learned judge is contravenes section 17, which again is perverse, the reasoning. He says you can't call him for anything. His statements which you have given will be quashed. This is a totally perverse judgment. It can't stand for a minute. Therefore, the order has to be should be stayed in toto, my lords. And my lords, may now have a look at the operative portion, my lords. And I have not cited the income tax judgment where the finding something in the search doesn't necessarily make the search bad. Now, look at the first operative portion of the order. The impugned search and seizure conducted at the residence of the petitioner on 28th and 29th, and subsequent statement recorded is vitiated on the grounds of absence of reason to believe. That can't be, because reason to believe is there, and the very fact that the predicate offense is registered is sufficient as far as the reason to believe is concerned. Therefore, this order is not only perverse, patently illegal. Second, statement recorded in the 17(1)(f) of PMLA is hereby ordered to be retracted. Pausing here for a moment, my lords. Supposing a statement or evidence, statement is evidence. If evidence is collected illegally, then also your lordship, the lordship of the Supreme Court in Puranmal's case says you can't shut that evidence out. Kindly have a look at Puranmal's case, my lords. That is, my lords, where is Puranmal? What is citation?
Puranmal, volume 2. Volume 2, serial number 7.
Volume 2, serial number 7 of my compilation, my lords.
Page 89. Para 23-24.
Page?
Page number 113 of my compilation.
Starts at 89.
Now kindly have a look, my lord. Para 20, my lords, may kindly have a look, my lords. There was challenge that the search and seizure was illegal because it infringes certain requirements.
Page 89. Starts at page 89.
Yes, starts at page 89. Kindly have a look at para 20, my lords. First.
Para 21.
20, my lords.
20. That is at page 112.
112, my lords.
Yes.
Apart from constitutional challenge, there is also further challenge on the ground that the actual search and seizure in all these cases being in contravention of requirements of so-and-so was illegal. So there was a contention that the search is illegal. That, my lords, may kindly note. Then, my lords, may kindly have a look.
Yes.
Now, kindly have a look at para 23, my lords. As the argument based on the spirit of a constitution, as to the argument based on the spirit of can do no better than quote from the judgment of Chief Justice Kanya in A.K. Gopalan's case. There is considerable authority for the statement that courts are not at liberty to declare acts void because, in their opinion, it is opposed to the spirit supposed to pervade the constitution, but not explicit words. Where the fundamental law has not, then I may skip this in, my lord. Now, if Evidence Act 1872 is a law consolidating, defining, and amending the law of evidence, no provision of which is challenged as violating the constitution, permits relevancy as the only test of admissibility of evidence. And secondly, that the act or any other similar law in force does not exclude relevant evidence on the ground that it was obtained under illegal search or seizure. It will be wrong to invoke the supposed spirit of our constitution for excluding such evidence. You can't exclude a statement which has been recorded. Which statement can be evidence, it's oral evidence. Even if the search is illegal, yet the learned judge, in violation of the judgment which is binding, says, exclude the statement. Now, kindly have a look at para 24. So far as India is concerned, its law of evidence is modeled in the rules of evidence which prevailed in English law, and courts in India and in England have consistently refused to exclude relevant evidence merely on the ground that it is obtained by illegal search or seizure.
This is breached.
This judgment, this binding judgment of Supreme Court is breached by these directions. Even assuming that my lords hold against me in the first part, the entire judgment has to go. The third, fourth point.
So we'll continue after recess or tomorrow, whatever suits you.
Whatever is convenient to my lords.
We'll continue after recess if your lordships can.
I have a matter in, I maybe, if pardon for a few minutes, if the matter is called up, most probably it's not going to reach, but if it reaches them in the first court, my lord, it might. I will try to, because I am almost at the fag end of my arguments.
Tomorrow,
I'll finish off in 5-10 minutes.
Tomorrow at...
No, today itself I'll finish off.
Today itself? Well.
Yes, I'll finish off. I'm always at the fag end of my arguments.
All right. So we'll continue.
Grateful, my lords.
Serial number 64, my lord.
Yes,
Appear for the
serial
petitioner in the
petition.
contempt petition. PWSSP has agreed to refund the money. May I request the matter to be taken up on 8th of April, my lord.
8th of April.
My lord, serial number 58, my lord.
Much, sir.
Time for respondent number 4 to 6, my lord. Not accommodation, I will file my objection.
Contempt petition.
Yes, my lord.
9th April.
What is serial number 32, my lord. After 2 weeks, I will file objections.
We'll go to appropriate date. Court officer will give the dates.
Yes.
Mental statements.
सर एक ओपिनियन दिया था स्टेट ऑफ सिटी का आर्बिट्रेशन मैटर में।
Give me the
versus State of Kerala, 1971.
number 13.
13. 1-3. Where is the board?
District.
13. 1-3. Yes, what do you want? Wait. This is leave to appeal.
The lordships leave.
Tomorrow at 2:30 we'll take.
The lordships.
Come tomorrow at 2:30. Because similar matter was there immediately, so we have kept it together.
The lordships leave, can I make a submission?
Operative personal.
Serial number 67 is the matter today, my lord.
67.
67.
Yes.
Wherein I'd made a mentioning last week, your lordship had directed for a judicial order to be put up and it's been posted at 67, where the committee constituted by your lordships is going, the tenure is going to get over by 28th of this month. And your lordship.
28th of this.
28th of this month. Your lordships by your order dated 5/7/2024 has restricted the inquiries to be taken by the G category committee, wherein it was earlier constituted by 3 members. Now it is by 2 members, wherein your lordship by order dated 5/7/2024 have restricted to only 67 files. And these 2 applications, what I have just filed right now, are beyond those 67 files. If your lordship's order is modified to that particular short extent, that these 2 files can also be inquired by the committee.
67 files are inquired.
67 files have completed, Your Honor. As on that day, the committee had made a report that 67 files are pending. But these 2 files, which applications which I have just filed right now, were not included in that particular list. So my files could not be inquired by the committee, my lord.
That 2 files include your.
Yes, my lord.
But the term expires in what way?
My lord?
Term of the committee expires?
28th of this month, my lord.
By virtue of our order?
No, my lord. The constitution, the work constitution gets over. If the committee does not inquire these 2 files without that constituted period, Again, they'll have to seek.
Period is constituted by virtue of some order?
Yes, my lord.
Which order? Earlier order?
Earlier order. Earlier order of your.
So in the meantime, one of the member died?
Yes, my lord. One of your member.
Extend the period. And
My lord.
we extend the period. And we'll direct the committee to look into those remaining file also.
Yes, my lord. That's the only grievance we are before your lordship.
Who appears?
BDA, Krishna appears for BDA here.
We'll take up at 4:15.
Yes, my lord.
Come at 4.
Yes, ma'am. In the meantime, I will just inform my learned brother.
Yes. You
Deeply
call out
obliged.
this matter at 4:15.
My lords,
Yeah.
kindly, my lord. Serial number 89 and 90.
Get the judgment, my God. He's sending.
Time for compliance, my lord. Kindly 10 days accommodation, my lord. Complete the complaints of Kannada translation. 89 and 90, my lord. 10 days accommodation. my lord. Partially I have complained, my lord.
1 second. So serial number 89 and 90. Separate order. The office objections will be complied with within 4 weeks. Failing with, the appeal shall stand automatically dismissed without reference to or order of the court. Same order in 89, 90. Then in 91 and 92 also same order, but time will be 3 weeks. Yes. Serial number? Serial number?
55.
55. Yeah.
In this matter, my lord, the order passed in writ petition has been passed in my favor, and the accused has not complied with the order, my lords, on the ground that they have filed a writ appeal. My lord, it's been more than 8 months, and this writ appeal has been coming to the registrar for non-compliance. And on the last occasion, it was a conditional order, my lord. I'm suffering because more than 200 customers are waiting for registration, my lord. And that's-
So when the appeal is going to be listed?
My lord, that we are not aware because I have a caveator in that appeal, my lord, caveator respondent.
It is lying under office objection. Then list it day after tomorrow with those 3.
My lords, my lords, I'm requesting that the contempt be taken up at 4:30, my lords, 4 o'clock.
When you are saying that appeal is filed, let them write, they have right to prosecute the appeal.
Not been
We'll see on day after tomorrow.
My lord, the
Appeal is getting listed. We'll get this listed also along with the appeal, your contempt. Day after. Oh, other listed.
Different issues. Different issues.
Just remind us.
Because this was given.
Make it separate.
Any order passed in 226.
Yes. Yes.
Hello,
Yes, Mr. Raju. Anything?
my lord, there are 2 or 3 small things which I have left out, my lord. The effect of this order would.
Let the mentioning be over. Let the mentioning be. Yes, Mr.
My lord, serial number 47, my lord. The
Yes.
small accommodation may kindly be given.
Pardon?
The small accommodation may kindly be given.
47. After summer holidays.
And,
PIL? No. PIL of 2020, no accommodation. Let it be called up. Yes. Yes, anything? Yes, Mr. Raj.
My lords may kindly have a look, my lords. This order has been followed on the
We will
very day it
continue-
was.
We will continue up to 3:45.
I'll finish in 10 minutes max.
No, you can continue. Your other side may continue, but up to today up to 3:45, because there is a matter which is to be taken up subject to the availability of lawyers, which is required by the Supreme Court to be heard.
Yes,
Preemptory.
My lords, serial number 115, we have complied, my lords. We will file it with an memo or affidavit.
Serial
my lords.
number?
115, my lords, totally complied.
What do you want? Day after tomorrow at 2:30.
The copy was not served in this matter, my lord, and for the complainant.
Day after tomorrow at 2:30.
Obliged.
Sir, my lord, I will, madam.
Day after tomorrow at 2:30.
Obliged.
Get the copy in the meantime. Yes.
My lord, the impugned order was passed on 27th of January 25.
Yes.
On that very day, one Parvati gets an interim leave, relying on this very judgment that is at page 15.
Now
So
you
right from
just,
day one, they.
Give the details of the cases of
That
the
is at
other
page-
accused. Give the
page
details,
15.
Mr. Kamath.
Lord, we
Page
have given it
15.
along with the application.
in a
Along with
Details
the,
of the cases.
yes,
Of
You have
other accused.
in a tabulated form, we have given the details of 6 cases.
Page.
Uh,
Page 10.
Page 10.
10 of the stay.
Page 10 of my IA, stay application.
After this, there were two more. That also we have produced.
Page 10, yes.
There were two more. So
They are what is the order you have not seen, given?
the orders are all, kindly have a look at first, my lord, page 15.
Orders are also produced?
Yes. Page 15. Page 17.
15 is a great number we issued.
But the order on page 15 is the same as the date on which the impugned order is passed. Maybe order is passed in the morning, in the evening, the order is passed in.
So the order is awaited.
Then the order is awaited. Yes, my lords may kindly have a look at page 15, my lords. My lords, may I read page 15? Learned senior counsel Sri Sandesh Chauta would submit that in the concerning another person to whom identical summons was issued, the coordinate bench of this court in writ petition has allowed the petition that notice has been issued. Notice so issued has been quashed. The order is awaited. Learned agents of the Council would be vehemently refuted the submission contain the enforcement that cannot be stopped from recording evidence or taking statements of any person, if it be it the accused or otherwise, and would submit the recording of evidence would in no way frustrate the proceeding pending before this court. I decline to accept the said submission. The court is seized of the entire proceedings and extend the time to file the report in terms of earlier order. There shall be interim order of stay. So even when it was.
This is 3296, same liquidation, which is relied upon. 2296. But it's the impugned order here.
Therefore, the impugned order here is relied upon even before it is uploaded and order has been obtained. And not only in the cases pertaining to this very case, but in different ECIR, special CC 127 of 2014, this was relied upon, that is page 26. My lords may have a look at page 26.
So the High Court itself is treating it in
Give me page 26. But 26 is a different proceeding concerning different matter. 26. This has nothing to do with the present case. It's not a co-accused or a witness in this case. Search is in some other matter. And my lords may see business.
2956.
Case is called out at page 26. Deputy Director, Directorate of Enforcement versus MS Salve Regina Charitable Trust. Nothing to do with the present matter. Different ECR. Case is called out. Accused number 1 firm, accused number 2 to 2, 5 and 8 present. Accused 3, 4 absent. EP filed accepted for the counsel. Accused number 5. 7 filed a memo along with online copy of order passed in writ petition 32956 or 24 dated so and so on the file of the Honorable High Court of Karnataka. The counsel for accused of submit the predicate offence procedural judgment. So it is relied in some other case also. So it is being treated as a judgment in rem.
Mr. Raju, what is this predicate offence? I do not know.
My lord, I'll tell my lord what the, my lord.
How this phraseology is used?
My lords are aware in PMLA there has to be an offence which is known as scheduled offence. Predicate is another word for a scheduled offence. Unless there's a scheduled offence, they kindly have a look at, my lord.
Scheduled offence.
Yes, scheduled offence is the predicate offence. If PMLA proceedings piggyback on a scheduled offence, there has to be a predicate offence.
According to you, this, yes. So according to you, this order is being relied on at various
courts. Therefore, it has a cascading effect. There are 8 orders, my lord, where this has been relied upon. Now tell my lords what will be the effect in the present case. Present case effectively investigation is stalled. All my searches have been quashed. All the evidence which has been recovered has been quashed. Sections have been quashed. Summons have been quashed. So what investigation will I do? An investigation is only on paper. I can't do any effective investigation.
Main accused Parvati summons quashed.
Main accused Parvati summons has been quashed. Parvati, the main accused against the summons is quashed. A result of an order should not be that the entire
Who is the main accused?
one Parvati, my lords.
Parvati.
Her statements, you can't record her statements, can't do anything just because the search was carried out at her place.
Additional affidavit.
Additional affidavit may be seen, my lords.
But on 18.3, we have filed additional affidavit and produced 2 more. 18.3.
Para 16, page 49.
Para 16, page 14 may be looked at.
49.
Page 49, I'm sorry. Please.
Impugn judgment is relied upon. It's just said, I will follow it, ordinance bench.
And page 49, the learned judge follows the impugned judgment, my lord, which my lords will find at last 2 lines of page 49.
Page 49 of additional affidavit.
Additional affidavit. And quashes the summons issued to the main account. What investigation will we do, my lords? Our hands are tied. So everything goes for a toss.
49 of which?
Additional affidavit, my lords.
No, it is running page of some judgment.
It is running page of an order passed in Parvati's case.
Parvati.
Parvati is the main accused, my lords.
Page 49, last page.
I therefore deem it appropriate to follow suit the findings of the coordinate bench. The coordinate bench in the case of Dr. Natesa DB, which is impugned before my lords,
Yes.
has held as follows.
Correct. The operative portion is at page 60.
It is extracted. Yes, my lord. It is at page 50.
Criminal petition is allowed. Enforcement case issued against the petitioner is post consequential actions, including summons. That is based on this judgment.
Yes, based on this very judgment. And what is stated, my lords, may have a look at page 50. The operative portion of this judgment has been extracted. Page 50. Operative. I'm sorry, brother. There's a mistake. Yes. Para 8 has been extracted. I'm sorry, brother. And then, my lord, para 9 has been extracted.
Let me go to 60.
Kindly have a look at page 60, my lords.
This is all right, but your argument is not inclusive of a submission. That statement which is retracted, therefore it is scored off from the record.
There is a retraction, there is one additional submission.
Kindly listen, and a statement which is retracted.
Yes.
Or order to be retracted, therefore
Yes.
scored off from the record, can
Yes.
be relied on in respect of the other accused.
It can be relied upon. The statement of Justice Vijay Madan Lal's case. It is admissible in evidence.
Where is that law?
Yes, Vijay Madan Lal. Vijay Madan Lal.
Where is that law?
Section
Any-
50. Yes, section 50 itself is clear. It is evidence. Kindly have a look at section 50. Section 50 statement.
Volume 1.
My lords may have subsection 2, my lords. Get me Vijay Madan Lal.
Volume 1.
That relevant portion regarding section 50.
Page 179. You need not be an accused.
All persons so summoned shall be bound to attend in person or through author. Subsection 2, my lords are having of section 50.
All persons so summoned.
So summoned shall be bound to attend in person or through authorized agents, as such officers may direct shall be bound to state the truth upon any subject respecting which they are examined and make statements and produce such documents as may be required. So this is a statement which was challenged that their police officers can't be looked at it by 25, 26, and Vijay Madan Lal says that it is evidence it can be. It can be looked at, my lord.
Page 170.
I'm sorry, my lord. I read 3 by mistake. The director, additional director, joint director, subsection 2. Deputy director or assistant director shall have the power to summon any person whose attendance he considers necessary, whether to give evidence or produce records. So section 50, you produce evidence, and evidence means something which is admissible in evidence. Now kindly have a look at Vijay Madan Lal, my lord.
Paragraph 431.
Paragraph 431, which is my compilation volume 1 at page 179. My lords are having it.
Which is not 431. Last line at 179.
The volume 1, page 179.
179. It's 180.
431. Correct.
My lord, may I read paragraph 431?
Yes.
By evidence is required to be produced during adjudication proceedings and also during the trial. Now kindly have a look at what the Supreme Court says. Page 430. Page 431. Paragraph 431. I'm sorry.
Page 179.
31.
431.
Paragraph 431 at page 179.
Yes.
In the context of the 2002 Act, it must be remembered that summons is issued by the authority under Section 5 in connection with inquiry regarding proceeds of crime which may have been attached and pending adjudication before the adjudicating authority. In respect of such action, the designated officials have been empowered to summon any person for collection of information and evidence to be presented before the adjudicating authority. It is not necessary for initiating a prosecution against the notary as such. The power entrusted to the designated officials under this Act, though couched as an investigation in the real sense, is to undertake inquiry to ascertain relevant facts to facilitate initiation of or pursuing with an action regarding proceeds of crime, if the situation so warrants, and for being presented before the adjudicating authority. It is a different matter that the information and evidence so collated during the inquiry may disclose the commission of an offense of money laundering and involvement of a person who has been summoned for making disclosure pursuant to the summons issued by the authority. At this stage, there would be no formal document indicative of the likelihood of involvement of such person as an accused of offense of money laundering. If the statement by him reveals the offense of money laundering or the existence of proceeds of crime, that becomes actionable under the Act itself. To put it differently, at the stage of recording of statement for the purpose of inquiring into relevant facts in connection with the property being proceeds of crime, is what the proceeds of crime is. In that sense, is not an investigation or prosecution as such. In any case, there will be no formal accusation against the notary. Such summons can be issued even to witnesses in the inquiry so conducted by the authorized official. However, after further inquiry on the basis of other material and the evidence, the involvement of such person is revealed, the authorized officer can certainly proceed against him for his acts and commission of the offense. In such a situation, at the stage of issuance, the person cannot claim protection under Article 20, subsection 3 of the Constitution. However, if for his statement is recorded after formal arrest, the consequence of Article 20, Article 3 or Section 25 of the Evidence Act may come into place to urge that the same being in the nature of a confession shall not be proved against him. Further, it would not preclude the prosecution proceeding against such person, including consequence under Section 3. So he can be called as a witness. And 20 Article 3 is incriminating. So if he's not arrested and the statement is recorded, that statement would be admissible not only against him, but again, it will be admissible even against him. Now that even if it is confessional in nature, it would not be hit by bar under Article 20, sub-Article 3 if he is not arrested. That is what the Supreme Court says. And then kindly have a look at Article, if there's a joint trial, it can be used against the co-accused. That is what Section 30 of the Evidence Act says. So if it is not hit against him, a confession can be used as evidence. It can also be used in adjudication proceedings. Therefore, the effect today is, supposing I want to arrest somebody who is involved in a PMLA offense based on a statement, I can do it. But if the statement is whitewashed, I can't do it. And my lord, retraction is generally done by the person who makes the statement. It is unheard of that the third person or the court retracts the statement. Nothing prevented him from retracting the statement. Day in and out, day out, persons under whose statements are recorded under the Customs Act retract their statements. It is for the first time I'm hearing that a third party, that is the court, is retracting the statements. Court could have quashed the statements, but court could not have retracted the statements. In any case, that statement, even if it is illegally obtained, cannot be whitewashed in Puranman's case, which I just cited. Therefore, my lords may kindly have a look. The order is perverse as far as the operative portion is concerned, my lord. That is, my lords, first, there's a clause, small Roman 2, small Roman 3, and small Roman 4. So 17th statement, 17th statement is retracted, 15 squashed. Even without perusing the statement, the court quashes it. Court must look at the statement and say why it is bad. Nothing, only because the court puts the cart before the horse, it puts the conditions required for the first portion of section 17 as if it is a condition required for the second portion. Therefore, there is a case where the order is patently bad in law. And, my lord, no prejudice would be caused to him today if the order is stayed. And if the order is permitted to be used against the others, and if that portion is also stayed, no prejudice will be caused. So both the portions of the IA am praying for may be allowed, my lord. This is my submission, my lords.
Very
Grateful, my lords. Just note down the points.
May it please your lordships.
Yes, Mr.
Lord, Mr. Raju's submissions, Lord, that the judgment deserves to be stayed, Lord, with greatest respects and all humility at my command, and with, Lord, utmost regard and affection for my learned friend, is completely without any basis in facts and law. Lord, the judgment of the learned single judge is absolutely valid, just, legal, and proper, and is in consonance with the statute as also law declared by the Honorable Supreme Court from time to time, including Lord Chaudhary's case, Vijay Madan Lal Chaudhary's case, and I will demonstrate that. Both in facts and in law, learned single judge is absolutely justified in the view that he has taken. Now, my lord, before I do so, let me tell your lordships one thing at the outset. Kindly note that, my lord, these examples of other judgments that have been followed, my lord, that is unfair to bring them before your lordships today without ED having filed appeal against those judgments. And Parvati's case, they have to go to Supreme Court because it is in exercise of powers under criminal jurisdiction. So, my lord, it is unfortunate that these cases are cited without challenging them. And stray lines are shown to your lordships that learned single judge's present judgment has been relied upon and followed. So, my lord, I respectfully submit that those cases must be, it would be unfair to those litigants, my lord, if your lordships were to be, my lord, prejudiced by these submissions which are being made today. The present judgment is the law. So far as state of Karnataka is concerned, it follows the law declared by the Supreme Court under Article 141 in Chaudhary's case, and High Court is bound to follow that.
Essentially, the argument appears to be that why these directions, which are given by learned single judge, while quashing the summons and directing the retraction of the statement, should hamper the investigation against the other accused. That appears to be the argument.
But that can't be the argument, because ultimately you have to challenge those cases and bring them up before your lordships for a stay.
No.
They can't get, but the judgment of your lordship's court laying down law is a precedent, and every litigant is, my lord, entitled to benefit of that precedent. I will show, my lord, a constitution bench judgment straight away to your lordships, Please turn to my lord 2020,
Yes.
volume 4 Supreme Court cases. Brilliant my lord analysis. 4 Supreme Court cases, page 1. Lord Dr. Shah Faisal versus Union of India, and paragraphs 17 to my lord 23 I place for your lordship's consideration. Para 17. Lord, I appear along with Miss Atrishi, as also Lord, my distinguished friend Mr. Jota. So, Lord, Miss Atrishi would Lord assist your lordships in the court. Para 17, kindly turn to. Lordships have para 17?
Yes.
Please turn to para 17. Lord, this is a brilliant analysis of Lord value and necessity of a precedent. This court's jurisprudence, para 17, my lord. Lordships have got?
Yes.
This court's my Lord Justice Arvind has got?
Please.
Yes, Lord. This court's jurisprudence has shown that usually the courts do not overrule the established precedents unless there is a social, constitutional, or economic change mandating such a development. Numbers themselves speak of restraint, and the value of this court attaches to doctrine of precedent. This court regards the use of precedent as an indispensable bedrock upon which this court renders justice. The use of such precedents to some extent creates certainty upon which individuals can rely and conduct their affairs. It also creates a basis for the development of rule of law. As Chief Justice of the Supreme Court of United States, John Roberts, observed during Senate confirmation hearing, it is a jolt to the legal system when you overrule a precedent. Precedent plays an important role in promoting stability and even-handedness. Please see the words. See the words which are used. Doctrine of precedent and stare decisis are the core values of our legal system. Core values. They form the tools which further the goal of certainty, stability, and continuity in our legal system. Arguably, judges owe a duty to the concept of certainty of law. Therefore, they often justify their holdings by relying upon established tenets of law. When a decision is rendered by this court, it requires a reliance of interest, and society organizes itself based on a present legal order. When substantial judicial time and resources are spent on references, same should not be made in a casual manner. Then not just see para 22 of Chandra Prakash, which is not extracted in para 19. The doctrine of binding precedent, Lord Chandra Prakash is also Constitution Bench judgment. The doctrine of binding precedent is of utmost in the administration of our judicial system. It promotes certainty and consistency in judicial decisions. Judicial consistency promotes confidence in the system. Therefore, there is this need for consistency in the enunciation of legal principles in the decisions of this court. At the extreme end of this doctrine, we have example of House of Lords, wherein until 1966, it never overruled its decision, but only distinguished them. It was said that an erroneous decision of House of Lords could be set right only by an act of Parliament. Of course, your lordships would recall that controversy between Lord Diplock, and Lord Mustill. Lord Mustill, sitting in Court of Appeal, would refuse to abide by judgments of the House of Lords. And that led to Lord Diplock making a comment on Lord Mustill and said that you can't do this. So, now kindly, therefore, this is what the value of precedents is. That is why, I respectfully urge that do not allow your lordships to be, influenced by the fact that the learned judge has followed this judgment in subsequent cases or other learned judges have followed. It's not just learned Justice Chandra Shekhar Gaundar has followed, Justice Nagaprasanna has also followed. And rightly so. I will show that. Now, my lord, please kindly appreciate one aspect, which is, my lord, singularly, my lord, relevant here, that there is nothing unreviewable under the Constitution of India. There is no action of government no order which is unreviewable. And that's what the Supreme Court has said. That's the beauty of our constitution. And that is why, my lord, the powers of the Constitutional Court under Article 226 and Article 32. Both the High Courts and the Supreme Court have powers to review every government order. My lord, be you may so high, howsoever high, the law is above you. Now, my lord, question here therefore is that, my lord, the learned judge relying upon Lord Vijay Madan Lal Chaudhary says, you have no power to embark upon this inquiry. You have no jurisdiction. My lord, Supreme Court has said for last 77 years that if an authority has no jurisdiction or authority to embark upon an inquiry, it is unconstitutional, it is void ab initio. And therefore, a writ court must interfere and set aside those actions. Large number of judgments, Coffee Board, Ujjambai, your lordships are fully aware of those judgments. I need not cite them. But my lord, the most profound statement comes is, my lord, in Minerva Mills, Chief Justice Chandrachud, Senior Chief Justice Chandrachud, 3 articles of Constitution, my lord. See this, my lord, profound statement. 3 articles of Constitution and only 3 stand between the heaven of freedom into which Tagore wanted his country to awake and the abyss of unrestrained power. Abyss of unrestrained power. That's what, my lord, ED wants your lordships to permit them to do. And I will show why they want them to do, my lord. These are Articles 14, 19 and 21. Now, my lord, if you have no power, 21 says you cannot take away life or liberty without authority of law.
I don't know what to note. What is his point?
Well, may I, with my lord's permission, only say one thing? I have never argued that the precedent should not be followed. Precedents can always be set aside in appeal.
I didn't interrupt you once.
Set aside the precedent.
Mr. Raju, I did
never
not
argued that
interrupt you
precedent.
once. Please don't
I am
interrupt
asking
me.
the permission of the
No,
court,
Mr.
sir.
Raju, don't take
shout,
permission.
Don't shout at me, Mr.
No, I'm not shouting.
I am
You
not
be
going to be
fair.
browbeated by your shouting. I am not going to be
Not
browbeated by your
browbeating.
shouting. I'm sorry.
Mr. Raju, you have argued exactly that.
No, I have
allow
not
me to
argued that.
argue.
I'm sorry. Don't put
Don't
words in my
interrupt,
mouth.
please. It's
Don't
a very
put my words
unfortunate
in my
that
mouth.
a
I'm
law
so sorry.
officer of your stature is interrupting.
No,
You have
I'm
had
not
your
interrupting.
chance.
I'm
Now
only
please
saying
allow me my
that
chance.
I never argued that the precedent is not binding. Where have I argued? I am only
Mr.
saying
Raju.
precedents can always be set aside in appeals.
Very well. You argue, Mr. Raju, whatever you want
Yes.
to. I'll argue. After you
So
have
I
finished
have never
your
argued what
argument,
you're trying to canvass.
Now you argue whatever you want to argue. Please argue, Mr. Raju. Say how I am wrong. Please argue.
No, leave for us some room to decide who argue what.
No, my
Very
lord,
well.
if your lordships will permit this interruption, it's not fair. I did not say one word when Mr. Raju argued, including making misstatements.
Yes. Yes, please proceed, Mr. Yes.
It's very unfortunate that law officers are, my lord, indulging in these interruptions just because they are law officers and because they abuse your lordship's kindness. They know your lordship's kindness and that's why they do it. Now, my lord, let me show to your lordships why, my lord, things are bad. As my lord, my learned friend is pointing out, my lord, what is his case? What is his case? Kindly turn to, my lord, his application for injunction.
Yes.
Please see his case, my lord. It's a gross case. There is no offense, there is no crime, there is no proceeds of crime. One kind gentleman, my lord, one fine day, just kindly note, on 27 September 2024, my lord, one public-spirited kind gentleman moves the Lokayukt court and says that all kinds of wrong things have been done by the chief minister and his wife has been allotted 14 sites. And in doing so, my client, the then Lord Muda commissioner, has indulged in wrongdoing. Now, my lord, there is no crime here. There is no, my lord, proceeds of crime here. And yet they want to start the inquiry and now extend the inquiry to hundreds and hundreds of people. After almost 20 years, my lord, these transactions between the chief minister and, my lord, his family and, my lord, the erstwhile owner of the land started in 2004. We are in 2024 when this Lord kind gentleman moves the Lokayukt court. Now, what are these allegations which Lord they make out in the application for injunction? Kindly turn to Lord paragraph 3 of the injunction application. Para 3 of the state petition. There is no case here, my lord. It's a gross abuse of authority which is not being perpetrated. Anybody can file, my lord. Tomorrow a complaint. Somebody files a complaint against me saying that I have misused my office as a lawyer. So, my lord, ED will step in and start inquiry.
Court directed, no? It's a court directed inquiry. It's a court directed inquiry.
Again, you are interrupting. Mr. Raju, my lord, has not told your lordships that the Lokayukt police has submitted a B summary report. And the Lokayukt court is considering B summary report and has reserved the judgment for 3rd of April. Now, if that is accepted, everything disappears. He doesn't say that because it doesn't suit him. The B summary report he hides from your lordships, knowing full well. Knowing full well. Now, please see para 3. Writ petitioner respondent herein is the former commissioner of Mysore Urban Authority.
The FIR was common.
Yes, same FIR.
The common FIR.
Yes, my lord. Same one FIR and all these. I'll tell you what is happening. Please kindly.
Crime number 11, members. Crime number 11 of 2024.
Pardon?
Crime number 11 of 2024. It arose out of a private complaint which was referred under 156(3). The crime number.
Mr. Chota, I will answer that, Lord. Mr. Chota, please allow me to assist the court. Thank you.
Sir.
Lord, it is the same FIR number 11, Lord, of 2024 in Lokayukt court. What has happened is the FIR was against Lord Chief Minister's wife and Chief Minister for having allegedly abused the authority and having got these 14 Lord plots allotted. Now, I will tell you, Lordships, what has happened. Lord, there is a statutory scheme under the Karnataka state, in the Karnataka state, under which if you have taken away land without paying compensation, you are entitled to be compensated by way of land plus compensation. Now, that Lord scheme is under statutory rules. In respect of this very transaction, Lord, the MUDA as an authority, statutory authority, met in Lord sometime in 2011, and it comprised of all honorable members of all political parties. The BJP, the Janata Dal, the Congress, along with who are all statutory members of MUDA. And they took a decision that we must give everybody this land in compensation in lieu of compensation. That decision nobody has questioned, my lord. That decision, those rules are not questioned. And, my lord, your lordship's court, Karnataka High Court, has in, my lord, 11 cases upheld this and said people must get the land. These, my lord, decisions came up to Supreme Court. SLPs have been dismissed. One of the judgment is by Justice, Honorable Mr. Justice Bopanna, his lordship then was in Karnataka High Court in Srimati Sunanda versus BDA in writ petition 16952. That lord came in appeal. Appeal was dismissed and SLP was dismissed by a bench comprising of Justice Nageshwar Rao and Justice Goel. Now, my lord, this is therefore, this is a power which has been exercised in favor of thousands of people. What now they are doing is that having, my lord, gone after the Chief Minister and his wife, the ED is now sending summons after summons to innocent citizens and saying, you come and explain to us. I will show. ED admits that in its appeal. So, my lord, first and foremost, there is no offense here because this was part of a statutory exercise. It was a policy decision upheld by Karnataka High Court and the Supreme Court. Now, please see, therefore, kindly turn Lord, straight away turn to Lord my counter first. I have explained that in my counter. My statement of objections, IA 2 of 2025. Kindly give that, Mr. Courtmaster, to Lordships. Statement of objections by respondent in IA 2 of 2025. How can there be, my lord, as my lord, your lordships would recall Justice Bhagwati's judgment in Nandalal Jaiswal, that if, my lord, a policy decision has been taken by a string of officers, not in the secrecy of their chambers, but in openness, then that can't be questioned. Take out Nandalal Jaiswal passage.
1 second, Mr. Raju. You are muted. You have to unmute yourself.
Raju, please unmute yourself.
I'm sorry, my lords. Yes, my lords.
Now, if provided you are right, and provided the court passes some order, say,
my
for
lord.
example, outrightly in your favor,
Yes, my lords.
then what will the effect or what will happen to the cases which are either quashed or stayed in respect of the other accused? Will they automatically revive?
No, my lord's order will be prospective in nature. It won't be retrospective. It will not have an effect of an order which is already passed. We will take remedy as far as those other matters is concerned. I am not asking that my lord's order will have an effect. On orders that are passed till date.
Also?
Yes.
My lord's orders cannot have
They are
retrospective
sending
effect.
summonses to not accuse. They are sending
I'm
summons
sorry,
to innocent people.
Mr. Dave, I've been put a question. Now, please don't interfere.
You did, Raju, and you didn't stop.
No, it will only affect the prospective. It will
When I
only
requested you, you didn't stop, Mr.
prospectively.
Raju. Did you? Mr. Raju, did you stop when I requested you?
It's not. I'm not
So
supposed to answer.
I have a right to interrupt.
You speak. You have a right. You speak, please. But the thing is, whatever order is passed today by my lords will have only prospective application. It cannot have retrospective operation.
So there are other accused also.
There are other accused. There are future. So if tomorrow, if I want to do something for future, it cannot. I will not use this order for any retrospective operation.
In this case, there are still other accused.
Other accused. There may be other witnesses. There may be other places where we may want to search.
There are 4 named accused. Still, yes. It says 4, and then it says others.
And as far as those orders
we wanted to ascertain that we wanted to ascertain that this exercise of hearing is not academic.
No, madam. Wherever orders are passed, surely my lord's orders will not affect that. Those orders which are already passed, we will have a remedy to challenge those orders in appropriate courts of law. That's a different issue, my lords.
Correct. Now that's all. Yes, Mr. This just occurred to me in the course of the year. Yes, Mr.
Kindly turn to para 6 of my reply, my lord.
Yes.
Because, my lord, the basic controversy is, my lord, worth noticing factually.
My lord, I'm called in another court. May I leave, my lords?
Yes.
Rightfully. My colleagues will be taking note, my lord.
Basic controversy, my lord, is completely, my lord, is divorce of PMLA Act. There is no predicated offense here. It is only in the realm of allegation of a public spirited citizen who has filed a so-called FIR before Lord Lokayukt court. And Lokayukt police, after investigation, has submitted a B summary report saying that there is no substance in it. The Lokayukt court has today reserved the order for 3rd April. And if it accepts B summary report, this FIR will go. Which should have been told to your lordships in the first instance. Now please see, my lord, how this arises. Para 6. In view of the above, the present application is completely misconceived and deserves to be dismissed without granting any of the reliefs prayed for. The appeal memorandum in para 4 is traversed as under. Para 4. FIR number 11 of 2024 dated 27/9/2024 was registered at Lokayukt Police, Mysore against Sri Siddharamaiah, Srimati Parvati, Sri Mallikarjun Swami, and Sri Devaraju. Lord, Parvati is wife, Mallikarjun is his brother-in-law, and Devaraju is the original landowner. and others under section 120B, 420 of IPC and 9 and 13 of Prevention of Corruption Act, which are scheduled offences. The allegation in FIR is that Devaraju illegally sold land to Mallikarjun Swamy. Now, my lord, this is where there is a false statement made in the FIR. Devaraju was the owner admittedly. They suppress in the FIR and say Devaraju had lost his right to the land. I have put on record, my lord, which I will read later in this paragraph, that Devaraju was the owner and family had relinquished, my lord, before the revenue authorities, their right, title and interest in favor of Devaraju, which is suppressed. Factum of denotification is suppressed. Factum of return of compensation by, my lord, district court is suppressed. And this FIR is filed saying that everything is illegal. Now please see further. Whose brother-in-law of Sri Siddaramaiah, present Chief Minister. The land was subsequently gifted to Srimati Parvati, who is the wife of Siddaramaiah. Land was notified by Mysore Urban Development Authority for acquisition to form so-and-so layout. The land was illegally denotified from notification. Now nobody has challenged denotification. He now says it is illegal. Whereas thousands of acres, my lords, lord would perhaps your lordships may be aware by now, sitting here, that thousands of acres of lands are denotified in every state. Karnataka is no exception. Farmers represent and they denotify. So-and-so. Land was illegally denotified from so-and-so. Subsequently, illegal claim for compensation was made by Parvati against the acquisition of land by using undue influence of Siddaramaiah, who is an influential politician occupying high constitutional post, 14 alternative sites in Vijayanagar layout, which is the affluent developed area, worth rupees 56 crore is given against 3 acres of land. These averments are factually incorrect and contrary to the record available on the file of government for over 45 years. First and foremost, the land in question was admittedly relinquished by the legal heirs of Mallaraiya's widow and son of late Mallaraiya, as also other surviving brother Mallaraiya, Devaraju, third brother. This fact was recorded by the Revenue Authority under relinquishment of rights. Annexure 1 is a copy of the recording of so-and-so. Subsequently, mutation was effected in revenue record in favor of Devaraju, vide so-and-so, where no objection of family members was recorded. But the FIR says Devaraju had no right to sell. Copy of mutation is so-and-so. Pursuant to the same register of tenancy and crops is also drawn up to reflect the name of Devaraju right from 1990 to 93. Devaraju was thus clearly the owner of the land, contrary to the statement in the said para as recorded in the FIR before Lokayukta. Subsequently, though acquisition proceedings were started in 1992, denotification was initiated on 24/7/1992 at the request of Devaraju and admittedly prior to final notification dated 20th August 1997. Now pause here. Lord Devaraju sells to brother-in-law of Chief Minister in 2004. 10 years later. And the allegations are made that there is a great conspiracy here. Devaraju is a poor farmer who is now 80 years of age. He is in appeal before your lordships in other set of matters. He had nothing. He sold it for a valuable consideration. Now all these facts, some public spirited citizen stands up and files an FIR and it becomes an offense. And people are harassed in this fashion, my lord. Now please see further. Denotification was done thereafter on 18th of May 1998, whereas notice of award was issued only subsequently on 15 to 1999. This being the position, even reference court in which compensation was deposited by Mudda on 15/3/99 returned the same by its order of 3rd September 99, holding that the procedure for deposit of the award amount is not as per law. The possession of land in question was not taken. An approved sanction layout plan shows the land as denotified area. The appeal memorandum records in para 18.2 and 18.3 as under that in present case, search and seizure was conducted on the basis of sufficient reasons to believe, as enumerated hereunder. Allegation in FIR is that Devaraju illegally sold land to Sri Swamy, who is brother-in-law of Chief Minister. Land was subsequently gifted to Parvati, who is wife of Chief Minister. Land was thus denotified by Mysuru for acquisition to form Devaraju layout. Land was illegally denotified from notification. Subsequently, illegal claim of compensation was made by Parvati against acquisition of land by using undue influence of Siddaramaiah, who was influential politician occupying constitutional 14 alternative sites, so and so were given. Now, para 8. Admittedly, despite the notification, award was made. Subsequently, on 25/8/2004, Devaraju sold the land to Mallikarjun Swamy for a consideration of 5,95,000 and possession was handed over. Land was converted, 2004, my lord. Land was converted for non-agriculture purpose on 15/7/2005 and 2010/2010. Said Swamy gifted the land to his sister Srimati Parvati, wife of Chief Minister. Thereafter, Srimati Parvati made a representation for compensation on 25/6/2014. Now just see next sentence. Efforts to get alternative plots failed despite MUDA having passed resolution to that effect on 15/12/2017 and 13/12/2017, despite Siddaramaiah then being Chief Minister. Now see this. In 2020, under BJP government, headed by Sri Basavaraj Bommai, passed a resolution on 20th/11/2020 for allotment of compensatory side. Resolution was passed by MUDA, inter-alia as under. Please see resolution. Decision on resolving issues with regard to lands taken over without acquisition. After detailed deliberation, it was decided that going forward, authority would, in cases of lands used without acquisition, where consent is given for the same, give compensation in the form of developed area in 50/50 ratio against the extent of 50% of the total land, which is developed portion. In the said meeting of MUDA, following members were present: Sri Rajiv, Chairman; Sri Ramdas, MLA, BJP, Janta Dal, Indian National Congress, Janta Dal, Indian National Congress, BJP, and Harshvardhan, MLA. In MUDA thereafter called Srimati Parvati to relinquish land in its favor by way of relinquishment deed of 25/11/2021. Thereafter, MUDA passed an order for allotment of site 50/50 ratio as per resolution of authority, and sale deeds were executed in favor of Parvati for 14 plots. It may be important to mention that MUDA's decision of 2011-21 was not in isolation, but followed a general policy taken by all development authorities in state, including Bangalore Development Authority and Shivamogga Urban Development Authority. Subsequently, realizing the misuse by some person, government on 27/10/2023 directed to discontinue state policy. Then Lord, Karnataka rules, para 10. For allotment of sites is statutory, as they provide for exercise of powers. Copy of the rules are annexed. It is submitted that all aforesaid documents are already as part of court record. It is submitted that there is no criminality involved herein. But this is what the case is. On this, Lord, somebody goes to Lokayukt court after Lord 10 years. And after Lord, I sold the land in 2004, this Devaraju, to this Chief Minister's brother-in-law. Now, Lord, on this kind of a complaint, Lord, this is filed, complaint is filed, your lordships may note two dates. On 27/9/2024, while complaint is pending, Lord, and investigation is ordered subsequently, Lord, on 1/10/2024, ECIR is registered by ED authorities. Solely based on this FIR. Solely based. Their appeal memorandum, their application for stay only rely upon these allegations of the FIR. That is why learned single judge says that there is complete non-application of mind. There is no reasonable basis. Now, please turn to the judgment of the Honorable Supreme Court in Lord Vijay Madan Lal Chaudhary.
Yes.
Lord, it's a complete misunderstanding on the part of Lord the ED that judgment gives them a license to do what they want to do. No, my Lord. With great respect, the judgment has inbuilt limitations and checks and balances, which your lordship may kindly notice. Now, please turn to my Lord para 235 for the objects and reasons of the act. Para 235. Anisha, can you give a copy of the judgment that I have same para with, so that lordships can have the same paragraphs?
It's the same para, sir.
Yes, my Lord. Kindly turn to para 235, my Lord.
Yes. 230.
The act was enacted to address the urgent need to have a comprehensive legislation inter alia for preventing money laundering, attachment of proceeds of crime, adjudication and confiscation thereof, including vesting of it in central government, setting up of agencies and mechanisms for coordinating measures for money laundering, and also to prosecute persons indulging in process of activity connected with proceeds of crime. This was felt world over owing to serious threat. Now see what was the object, my lord. Owing to serious threat to the financial systems of countries, including to their integrity and sovereignty because of money laundering. International community deliberated over dispensation to provide address serious threat posed by process and activities connected with crime. So UN Convention Against Illicit Traffic in Narcotic Drugs, Basel Statement of Principles, FTA established summits of several major nations. Now, my lord, please see introduction below that. Right at the end, my lord, at the foot of that, same page, the United Nations Convention, lordships have that? In introduction, left side.
Yes.
Left side is introduction. But at the under that statement of objects and reasons, it is being realized world over that money laundering poses a serious threat not only to financial systems of country, but also to their integrity and sovereignty. Some of the initiatives taken by international community to obviate threats are as under: United Nations Convention Against Illicit Traffic in Narcotics, Basel Statement so-and-so, Financial Action Task Force so-and-so. But the idea was to fight terrorism, drugs menace, things like that. Not some action taken by government over a period of 25 years. This was the underlying objective. Now kindly turn to paragraph 243. 243. Even the preamble of the act reinforces the background in which the act has been enacted by the parliament, being commitment of the country to the international community. It is crystal clear from the preamble that act has been enacted to prevent money laundering and to provide confiscation of property, etc., etc. Now please see para 257, Manoj. 257, Manoj.
Yes. 257.
Lord, omit the first part of the para. Lord, the recommendations at the foot. India was a party to it, to this convention. Then at the end, your lordships will find Vienna and Palermo Convention to establish a criminal offense for following knowing international acts, conversion, transfer of proceeds of specific purposes, concealment, disguise, so-and-so, so-and-so.
Where you are reading?
Para 257, Lord.
Yes.
Where it begins, at the end of it, recommendation 1 at the foot.
Yes, recommendation. Correct.
1. So, my lord, India passed this law in accordance with the Vienna and Palermo conventions. Then lordships may omit all that and come to page para 258. Para 258.
Yes.
My lord, just above the quotation, after 10 lines in para 258, we first note the speech of then Finance Minister made on 2/12/1999 in Lok Sabha. The Foreign Exchange Regulation Act primarily made compensatory transactions known as hawala illegal. The basic aim was to ensure that no one contravenes exchange control regulations through unofficial channels. The emphasis was therefore on violation of foreign exchange. Money laundering, that is cleansing of proceeds of crimes. Which crimes? Please see this, Lord. Such as extortion, treason, drug trafficking, gun running, pose a serious threat to integrity and sovereignty of country and to its financial system. For this is a draconian act. It is part of an international convention that it has been brought by parliament to fight these kind of cases. It is sad that it is now being used against every citizen for everything. Now please see 259, para 259. This speech thus set the tone for the years to come in our fight against money laundering. This law was enacted in 2002, yet brought into force in 2005. Later, a speech was made by then Finance Minister who introduced the Prevention of Money Laundering Bill in Rajya Sabha. Mr. Chairman, sir, I am grateful to the honorable members, especially to members who have spoken on this bill and supported the bill. Naturally, some questions arise. They have a reason. It's my duty to clarify. Sir, firstly, we must remember that money laundering is a very technically defined offense. It is not the way we understand money laundering in a colloquial sense. What it is understanding in a colloquial sense. It is a technically defined offense. It postulates that there must be a predicate offense and it is dealing with the proceeds of a crime. That is the offense of money laundering. It is more than simply converting black money into white or white money into black. Then, my lord, kindly omit all that. Now, please turn to, my lord, on section 3, para 263. How do you enter, my lord, the inquiry? Para 263. And that is where jurisdiction comes, my lord. It starts at 263, and my lords may kindly turn straight away to 269. Just note, my lord, 263 is the beginning of interpretation on section 3, but at 269. Section 17 is not relevant. What is relevant is section 3. Do you have power to embark upon this inquiry? In my respectful submission, no, says Vijay Madan Lal Chaudhary. From the bare language of section 3 of the 2002 Act, it is amply clear that offense of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime which had been derived or obtained as a result of criminal activity related to or in relation to scheduled offense. Now, what are the proceeds of crime here? And Lord, I must tell your lordship, Srimati Parvati has returned 14 plots back to government. She has returned them. But these plots can't be proceeds of crime. There is no crime here. And they are not proceeds of crime. Now, please see further. The process of or activity can be in any form. One of concealment, possession, acquisition, use of proceeds as much as projecting as untainted property. Last sentence of para 269. This offense otherwise has nothing to do with criminal activity relating to a scheduled offense, except the proceeds of crime derived or obtained as a result of that crime. Please note this sentence, Lord. Last sentence of para 269. Please see last sentence of para 269, my Lord the Chief Justice. Yes. This offense otherwise has nothing to do with criminal activity relating to a scheduled offense, except proceeds of crime derived or obtained as a result of that crime. Now, my Lord, can it be said that exercise of this plot denotification, Lord, a payment allotment of plots, framing of a scheme, rules, and this resolution of Muda in 2011 are criminal activities?
All right. Now we'll postpone it to tomorrow because.
Very well. What time, my Lord, your lordships would?
Whenever in the second half or.
2:30?
2:30.
Oh, no, my Lord, then my colleague says in the morning. I have a part at 2:30.
Morning? In the morning?
Morning.
Well, second half is fine for us.
Oh, I have to argue.
So at around.
Mr. Raju can rejoin in second half.
12:30? 12 or 12:30?
Yes, my Lord. 12 o'clock. 12 o'clock.
12 o'clock.
Very well. Very well. Deeply obliged.
Deeply obliged.
And tomorrow, how much time Mr. Dave will take?
About another 45 minutes.
About 45 minutes.
Yes, my Lord. I have to cite, maybe 1 hour. I have to cite 2 more judgments, which are squarely on the point.
No, you are welcome to only to assess the.
Yes, my Lord.
Our time, yes.
Grateful.
So
Deeply
12 o'clock tomorrow.
Deeply obliged. Vote is rising.
It's one change.
Anything?
Grateful.
So,
Number 67. Chandrachud. Number 67.
Call out smart class. So call out that.
Number 116.
Been understood it.
We proceeded with,
Yes, yes. I'm ready.
everybody is ready? Objections.
I only hope that it may not end today.
No, I'm hoping it'll end today. Sir. He said, I'm hoping it may not end today.
It
I
will
said,
not end.
I said, I'm hoping it'll end today.
No, it will. It can.
So far as this writ appeal is concerned, it's in a very narrow compass, my lord. I think
One. Since this is a new bench, after, where is that Supreme Court order? Where is it?
The Supreme Court order, we took up the matter, an interim order was granted, we took up the matter Supreme Court. Supreme Court said since the case is already posted for final hearing, we don't interfere. In the event of there being a adjournment, you move, your liberty was given to move for a vacating of this.
See, that is the only, I am aware of. The bench is new, brother, let the brother see. That is the one. Can you show?
I am sorry.
yes.
Specs are not that.
It's
small.
not, no, I'll give you a lot. It's actually, my lord, in this case, there were, my lord, a set of writ petitions. We have challenged, my lord, the order passed by the learned single judge with respect to one writ petition. Though there are various other issues involving various other parties in this case, the issue, my lord, that we have challenged before your lordship in this writ appeal pertains only to Mr. Kemparaju, who claims to be one of the claimants to 160 acres of land.
One second. So Camp Raju's claim over 162 kilometers.
Kemparaju's claim over 160 acres, 160, my lord.
0 acres. It's open land.
Beg your pardon, my lord?
It's an open land.
Open land, open land.
So 160 acre is a village.
No, no, the entire village is 500 acres. 500 acres, out of which he claims 160 acres.
Yes.
If my lord kindly takes my list of dates, my lord, I think the entire story will be there in this list.
Now, first let us see the operative part of learned single.
Yes. Page 125.
So we are concerned with which petition?
Lord, we are concerned, Lord, with writ petition number 23144.
2311.
I'm sorry, 27409, Lord.
No,
that is the first
I
order.
think 2740.
2740, my mistake. 27409 is allowed.
Only one.
Only that.
Only one appeal.
Only one appeal. I've not challenged, my lord, the orders passed in the others. I've only challenged the order in writ petition 27409.
Is
And I
allowed
think
finding recorded by the land tribunal.
Bangalore North Taluk in impugned order 22nd May 2017 is set aside. In respect of claim made by petitioner Kemparaju, the revenue authorities are directed to mutate the records in the name of legal representatives of Kemparaju in respect to the land to an extent of 160 acres, which is the subject matter in original suit number 93 of 1953. Execution petition number 151 of 1964.
The suit is also pending.
No, there's no suit. The suit, I'll give you a lot of what the suit also is. This suit, how, my lord, they come about this 160 acres is on the basis of a mortgage. On the mortgage, a suit is supposed to have been filed. And in execution of that
claim is based on what right? What kind of right?
He claims, my lord, that he's a purchaser of the property.
Purchaser.
Purchaser.
Regular sale.
Sale. A sale through court.
Through court.
Through court. He's a, no, I'm sorry. He is the purchaser from a person who purchased from court. One Doddaya purchased 160 acres from court. He purchased 160 acres from Doddaya. And my submission, Lord, is in the context of the Inam's Abolition Act, that one fact is the most irrelevant fact. That fact of sale is completely of no relevance to determine a question of who's entitled to be granted any rights with respect to this land. This, my lord, is the order of the learned single judge. Now, if your lordship takes a list of dates, my lord, these list of dates are specifically made with respect to Mr. Kemparaju. I am not dealing with the other claimants with respect to this land. My lord, first is Chalamakunte village, that is measuring about 500 acres, of Devanahalli Taluk, presently Bangalore North Taluk, was originally a Jodi village. And one KP Ramaya was the Jodidar. This is an undisputed fact. No one disputes this.
Jodi village.
A Jodi village, my lord, under the Personal and Miscellaneous Abolition Act, Miscellaneous Inams Abolition Act, there is a concept of a Jodi village, which is an Inam. And an Inam granted, my lord.
Kind of Inam.
It's an Inam.
So that word figures in the Inam Abolition Act?
Yes, my lord. It is there. The Jodi village is defined in the Inams Abolition Act.
Yes.
Then, my lord, in 16/7/1943, Kaveri Reddy purchased the entire 500 acres of Chalamakunte village from the Jodidar. So, my lord, Kaveri Reddy becomes the Inamdar. Under law, it is either the person who is the Inamdar or the person who claims through the Inamdar. 29/10/1948, it is claimed that Kaveri Reddy had executed a mortgage deed in favor of one Doddaya.
It's not Doddaya, it's Munibairappa. Please see your document. Exhibit Annexure Munibairappa.
Okay.
That's, the mortgage is not in favor of Dodaya.
Okay. Correct it, sir. It's all right. It's
I just want to correct.
very well. I'll make that correction. Maybe it's in favor of Muni Bhairappa. It may be my mistake.
In favor of
Muni Bhairappa.
Bhairappa.
Munirappa.
Muni Bhairappa. It's annexure A of the
Writ petition.
writ petition.
So it is claimed this mortgage deed was an extent of 160 acres of land. No permission, Lord. This is, your Lordship may only mark this, I'll show your Lordship the act. No permission was obtained post facto under the Mysore Alienated Villages Protection of Tenants and Miscellaneous Provisions Act 1950. Without such permission, the mortgage is void in law. I'll show your Lordship that act later. Lord, in 10/3/1953, a suit was filed for recovery of money by Dodaya or Muni Bhairappa?
Dodaya.
Dodaya.
The two are different people.
Two different people. Very good. No, actually, I'm correct on this one. This is a suit, my lord, which is pending on that day, 1953. In 1956, Kaveri Reddy, my lord, who was the Jodidar or the Inamdar, sold the entire extent of 500 acres in favor of Kempaiah by document number 561 of 5657. This fact also, my lord, is not denied by any party. Not Kemparaju, my lord, it's Kempaiah, another person.
Even at the time of admission, I was little bit confused. Kempaiah and
Yeah, Kempaiah, my lord, was.
therefore I saw what he did.
Yes, Kempaiah held 500 acres
Yes.
because the sale happened.
So they are related person.
No, 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 no. Kempaiah is not to Kemparaju. So Kaveri Reddy sold it to Kempaiah on 17/5/1956. Then, my lord, by which time, my lord, the Inams Abolition Act had already come into force in 1954, because it's the Mysore Personal and Miscellaneous Inams Abolition Act 1954. On 1/2/19, and this, my lord, is the critical date. 1/2/1959, a notification is issued by the government vesting the said property of 500 acres to the government in terms of the Mysore Personal and Miscellaneous Inams Abolition Act 1954. With this notification issued by the government, all rights whatsoever, including attachments, mortgages, etc., cease to exist, and the property vested with the government free of all encumbrances. Therefore, my lord, for this particular property, a notification was issued. Because under the Inams Abolition Act, the act, my lord, must be made applicable to each of the villages. And therefore, a notification fixing a date when the land vests with the government is 1/2/1959. Give me the number.
So this notification under which section? It is notified as Inam land.
Yes, my lord. Earlier it is an Inam. The object, my lord, of the Inams Abolition Act is to abolish all Inams.
It was abolished.
Yes, the act abolished all Inams.
No, by virtue of this notification, what was provided?
It vested the property with the government. It's vesting, my lord. If my lord kindly comes to section 2(2). My lord has the personal and miscellaneous.
Section 2 is definition.
Definition. Please see section 2(2), my lord, date of vesting.
Correct.
Date of vesting in relation to an Inam means the date appointed by a notification issued under subsection 4 of section 1 to be the date on which the provisions of this act, other than sections 1, 2, 27, 38, and 40, shall come into force in such Inam. Therefore, that is the date of vesting. Then, my lord, we kindly see section 3 now. Section 3, my lords. Consequence of the vesting.
Yes.
When the notification under subsection 4 of section 1 in respect of any inam has been published in the Mysore Gazette, then notwithstanding anything contained in any contract, grant, or other instrument, or in any other law for the time being in force, with effect on and from the date of vesting, and save as otherwise expressly provided in this Act, the following consequences shall ensue. Namely, 1. The provisions of the Land Revenue Code pertaining to alienated holdings shall, except as respects minor inams to which this Act is not applicable, be deemed to have been repealed in their application to the inam, and the provision of the Land Revenue Code will apply. Then B, my lord. All rights, title, and interest vesting in the inamdar, including those in all communal lands, uncultivated lands, whether assessed or not, wastelands, pasture lands, forests, mines and minerals, quarries, rivers and streams, tanks and irrigation works, fisheries and ferries, shall cease and be vested absolutely in the state of Mysore, in the state of Karnataka, free of all encumbrances. If I may say so, my lord, the consequence is almost like acquisition of land. The entire right, title, interest in the property vests in the state, straight away. Then Lord C, inamdar shall cease to have any interest in the inam other than the interest expressly saved by or under the provisions of this Act. D, all rent and land revenue, including cesses and royalties accruing in respect of lands comprised in such inam, on or after the date vesting, shall be payable to the state and not to the inamdar. Any payment made in contravention of this clause shall not be valid. Then next is also may not be relevant for this case, that is areas of revenue. Then if your lordships kindly come to F.
But the subsequent purchases or even inamdars?
No, in this case not. Because the purchase happened after the date of vesting. Once the properties... No, which one? No, the sale not in favor of Kaveri, in favor of Kempaiah was before the date of vesting.
Before the date.
Before the date. So Kempaiah sale is valid. If my lord sees in 56.
No, question is not that.
Yes.
Ramaiah was a Jodidar.
Yes.
So inam was in his favor.
In his favor.
So when the subsequent the purchaser purchased from Kaveri.
Yes, ma'am. Kaveri Reddy.
She could be said to have stepped into the
shoes of Ramaiah.
Inamdar.
Yes, ma'am. Because your lordship will see the definition of inamdar.
Definition of inamdar.
That is 2(6). Inamdar, my lord got that? My lord says
successor.
Successor in it. Therefore, anyone who succeeds to that interest is the. But all of that, lord, is up to 1959.
So that notification resolution 4-1 was when? 59.
1-4. 1-4.
4-1, 1-4.
1-4. 1-4.
1. So all sale thereafter will.
Everything else after that can't be done.
According to you will not.
Yes, ma'am. And
hold valid.
All goes. As a matter of fact, even if the property is under attachment by the court, because one of the findings of the learned single judges, property is under attachment by the court, and therefore that could not have been sold, is one of the findings. But please see F, section 3(1)(f).
You will continue the chronology or?
I'll just finish this one aspect, not since I'm reading it, and then I'll come to the chronology.
Section
3(1)(f).
3(1)(f).
F.
No such
inam shall be liable to attachment or sale in execution of any decree or other process of any court.
Yes.
And any attachment existing on the date of vesting or any order for attachment passed before such date in respect to such inam shall, subject to section 73 of the Transfer Property Act, cease to be in force.
Read again. No such inam shall be liable to attachment.
or sale.
In execution of any decree. So in respect of decree which is passed before the notice.
Passed before, after, in this case, what has happened, my lord, is execution has been done after, and on that basis, a sale executed by the court in favor of Dodaya. That could never have happened.
But then
It's
this
in the
subsets- According to your submission, the subsequent effect of this clause F is prospective nullifying of the decree.
Yes, lord, it never could have existed in law because the property did not belong to anybody for it to be sold. It was the state property because by virtue of 3(1)(b),
No decree could have been passed.
no decree could have been passed, no execution could have been done.
Even no decree would.
No decree also couldn't be passed.
Even the subsequent suits. Correct. The suits will not lie.
No suit will lie.
That's correct. And
this, my lord, is the position insofar as the concept of vesting. Now, please come back to the list of dates, my lord.
Section 8.
No, the list of dates. My lord was seeing 1/2/1959. That is a notification. Then, my lord, 1964. In 1964, execution proceedings is filed where the said extent of 160 acres is brought to sale.
Execution for what?
For a decree of money.
Very good.
My lord, that your lordship saw on the previous page, 10/3/1953. The previous page.
It was filed with Dodaya is a third party.
Huh.
He had some claim against that.
He had some claim, my lord, against
Munirappa.
Kaveri Reddy.
Where's Munirappa?
No, Kaveri Reddy.
Kaveri.
Kaveri Reddy.
Yes.
On the basis of that decree, which was granted by a court, execution proceedings were initiated in 1964. And in 1966, a sales certificate is issued in favor of Dodaya. That is 19/8/1966. Then on 21/3/1968, Dodaya sold the property in favor of Kemparaju. This is, my lord, how Kemparaju got title. If, my lord, the sale could never have happened by the court in 1966 because of the prohibition in section 3 of the Act, there is no title which was vested in Dodaya, and therefore Dodaya could never have executed a sale deed in favor of Kemparaju. Dodaya purchased the property in the sale, and then he executed a sale deed in favor of Kemparaju.
So execution was allowed.
Yes, execution was allowed.
Sale certificate was issued.
Sale certificate was issued.
Dodaya was treated the owner.
He became the owner.
Transferee owner. And then he sold to
this person, Kemparaj. The question really, my lord, is whether that entire proceeding is a nullity in law and whether any title could have been conveyed by the court because it would have had to convey it from the original owner. And the original owner had no title on that day because in 1959, the property stood vested with the government, free of all encumbrances. Which is why F clearly provides any attachment, any execution, everything goes. And for a person who claims as a mortgagee or anything else, he, my lord, has a separate provision in law where he can make a claim for money, not for the property. And I'll show you, lordship, that provision under section 24. This is not, my lord, what he could have done and said, I have now become the owner of the property, which is why the learned single judge.
Who could have conceivably such claim?
Dodaya also couldn't have made a claim. Dodaya couldn't have made a claim, my lord, because.
For whom the claim for mortgage will survive?
But the claim for mortgage will survive for payment of money under section 24.
For whose favor?
That, of course, Muni Bhairappa seems to have a mortgage. Therefore, Muni Bhairappa can make a claim on the basis of the mortgage.
So the last owner, rightly or wrongly, was this Dodaya.
No more. Last owner was Kaveri Reddy, and then he sold it to Kempaiah in 1956.
So last owner before notification was Kave.
Kempaiah.
Sorry, Kempaiah.
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 17/5/1956, the last entry.
Correct.
Kempaiah was the last owner.
56.
56.
So he will have the claim, she will have the claim for mortgage.
He'll have the, no, not mortgage. He will have the claim, Lord, for being re-granted the lands.
Re-granted.
Re-granted. Now, in the Inam Abolition Act, the concept, Lord, is either the tenants or the Inamdar must make an application to the government, and the land tribunal will decide who amongst them is entitled to the lands.
There is a provision.
There is a provision. The Inam Abolition Law abolishes Inam and then re-grants it to the tenants or to the Inamdar. If there are tenants, tenants get it. If the tenants are not there, then the Inamdar gets it.
So in other words, even after notification under section 1(4),
yes,
some rights will survive for the earlier owners.
No, the right to be re-granted survives, nothing else.
Something is
Yes, no.
Some claim.
Yes.
Whether grantable or not grantable, different.
True. That is to be decided by the tribe.
Some claim is surviving.
Absolutely.
All.
Now, with respect to that, Lord, there are very many applications which came. One, Lord, obviously an application by Kempaiah. Kempaiah said, I am entitled to this 500 acres, therefore please grant it to me. Then there were three others who also, Lord, claimed to be brothers, who said, we are also entitled to a share in this property, and they had sold some portions as well. Therefore, the purchasers from them also came and said, we are entitled. What is necessary in this act, my lord, is that there must be an application within the time specified. If there is no application within the time specified, then your right to even that property goes. Therefore, there is a time fixed, and the time finally came to an end in 1979 by virtue of an amendment to Section 10.
So this claim is under Section 10.
Yes. Section 10, Lord, is a consideration. It's an application under 9.
For re-grant.
For re-grant.
Yes.
This is our application under 9. No tenants, my lord, have made a claim. In the case, my lord, of Kemparaju, there was no application at all. The only time, my lord, he came was in the year 2000, when he made an application to be impleaded as a party to these proceedings, where, my lord, there are a lot of disputes otherwise going on.
Which process?
This proceeding, my lord, where what happens, my lord, is under the scheme of the Act, all applications for any particular land are taken up together and decided. So if there are 5 claimants.
There are applications under Section 10.
Yes, ma'am. 10 is the consideration. 9 is the application provision.
9.
9.
So at the stage when Section 9 those things were pending, 9 and 10.
My lord.
This Kemparaju applied for becoming a party.
Applied for becoming a party. He did not make an application. He applied to become a party in the proceedings.
Which year?
1810-2000.
1810-2000.
2000.
Really was not in picture.
No, till then, no, my lord. No news of Kemparaju at all.
Yes.
Therefore, if my lord now looks at the Act for a minute, I'll just show your lordships how the application must be made and how it has to be determined. Section 9, my lord. Every Inamdar shall with effect on and from the date of vesting, be entitled to be registered as an occupant of all lands other than certain classes of land. I won't trouble you lots with that. Then 2, every building situated within the limits of the Inam, which is owned immediately before date of vesting by Inamdar, shall with effect on and from such date vest in the Inamdar. In this section, Inamdar means an Inamdar other than a holder of a minor Inam, referred to in section 7. This is, my lord, the application provision. Now please see 10, my lord. How the process has to be followed. Determination of claims under sections 4, 5, 6, 7, 8, and 9. The tribunal shall examine the nature and history of all lands in respect to which a Kadim tenant, a permanent tenant, a quasi-permanent tenant, the holder of a minor Inam, or an Inamdar claims to be registered as occupant under sections 4, 5, 6, 7, and 9, or the holder of a minor Inam claims to be registered as a holder under section 8, as the case may be, and decide in respect to which lands the claims should be allowed. Then 2, a tenant found to be in possession of any land on the 1st day of July 1948 shall be presumed to be a quasi-permanent tenant as defined in clause 14 of subsection 1 of section 2, unless the Inamdar proves that such tenant is not a quasi-permanent tenant. Then Lord, please see 3 now, and that in my humble submission is important. No person shall be entitled to be registered no person shall be entitled to be registered as an occupant under sections 4, 5, 6, 7, and 9 unless the claimant makes an application to the tribunal. Therefore, the requirement, my lord, is an application to be first made in a particular form, which is there in the rules. Every such application shall be made in respect of lands in Inams which are vested in the state before the commencement of the Karnataka Inams Abolition Act, 1973, within 6 years from the date of commencement of the said Amendment Act, and in respect of lands in Inams which vest in the state on or after the commencement of the Karnataka Inams Abolition Laws Act 1973, within 3 years from the date of vesting of the Inam concerned, or 31st December 1979, whichever is later. Therefore, my lord, an absolute limitation on when it can be done. 6 years from 1973 to 1979. Therefore, December 1979 is the absolute cutoff date for anybody to make an application. Then please see B, where no application is made within the period specified in clause A, the right of any person to be registered as an occupant shall stand extinguished, and the land shall vest in the state absolutely. Such land shall be disposed of in accordance with the rules relating to grant of lands. Then not the mechanism of Land Reforms Act has been made applicable to this.
So Land Reforms Act not applicable.
No, some provisions have been made applicable. Section 48C, A, C, and 112 shall mutatis mutandis apply to an inquiry for determination of a claim under the section, and the decision of the tribunal shall be final.
So claim will be examined in light of this, as per this provision.
Yes, ma'am.
Now the tribunal
my lord, rejected his claim on 2 grounds. One, of course,
of Kemparaju.
Kemparaju's claim was rejected, my lord, on the simpliciter ground that there is no application filed before 1979.
So this application would lie to the tribunal?
Yes, my lord. The application has to be made to the tribunal.
Will examine it. Yes.
And the tribunal must then examine it. Actually, my lord, evidence is taken. Oral evidence also is led before the tribunal, and then the tribunal makes a determination as to who's entitled to the land. In this case, my lord, the tribunal held that Kempaya is entitled to the entire extent of land because of the purchase from Kaveri Reddy, and therefore, since he's entitled to the entire 500 acres of land, subject to land ceiling, a certain extent is to be granted. We challenge that, my lord, saying land ceiling, that tribunal could not have decided because that is a separate decision to be made. There are various other claimants also came before the court and said that the rejection of their claims is wrong. Therefore, those claims were also before the learned single judge. The third petition, which is Kemparaju's petition, Kemparaju said, my rejection is wrong, and therefore I should be granted 160 acres of land. For today, my lord, really issues in a very narrow compass in my respectful submission. Whether Kemparaju, my lord, first has made an application before the last cutoff date of 1979 or not is the first question in my humble submission.
So the application was post 31st December.
It was admittedly on first time he came on record at any proceeding was in the year 2000. He was not there at any point in time earlier. And it was not his case, not that he has made an application earlier or at any point in time earlier. Now, of course, they're trying to say there were some burnt records, destroyed records and all of this, but in all proceedings which were there earlier, Kemparaju's name has never appeared. It has always been the other claimant.
Time limit is condonable.
No, my lord. 1979 is the cutoff date. Cutoff date.
It is a kind of cutoff date. Yes.
This, my lord, is therefore, in my humble submission, insofar as Kemparaju is concerned, there are two issues. One is the cutoff date, and the second is, can he claim any title with respect to a property which has been transferred after the land vested with the government? Who? Kemparaju. Kemparaju's claim, my lord, is in the year 1968, when the property was sold to him by Doddaya. Kemparaju's claim, my lord, for title with respect to this property, if my lord looks at the list of dates,
21st March.
1968. For that to happen, my lord, Doddaya should have title. But Doddaya's title, my lord, does not exist because in 1959, the property vested with the government, free of all encumbrances. And any attachment or any proceeding with respect to the property could not have continued.
So section 9 application is available to whom? Which class of letters?
Yes, ma'am. The 9 application is available to tenants and inamdar.
Every inamdar.
Every inamdar. Every my lord, meaning that whoever is the last.
After this notification, nobody remained inamdar.
No one. After the notification, inamdar bet, he becomes a former inamdar.
So according to you, this Kemparaju was debilitated for 3 reasons. Number 1, he was never in Amdar.
Never.
Number 2, he never received a valid title from this Doddaya.
From Doddaya.
And number 3, the application was after 31st December 1970. In any case.
No, my case is no application.
No application.
No application. An application for impleadment is no application in terms of this provision.
Implead only.
Only impleadment.
Where is that application?
Yes. That. That's all. That's application. Lord, may kindly come to page 188. (199) is the typed copy of the order passed by not by the Karnataka Appellate Tribunal.
Yes. Appeal 1035.
1035. I think, my lord, the facts as stated by the applicant itself is very instructive at page 201. para 2, my lord, I'll just read that one para which will give my lord his entire case, which has changed over time. My lord has it. Para 2, my lord. Land bearing survey number 1 to 104 of Chalamakunte village, Jalahodli, Bangalore, measuring 494 acres. Are Jodi Inamdar lands. One Nanjappa was Jodidar of Inam, and the lands were partitioned by the sons of Jodidar Nanjappa, namely Kaveri Reddy, Timma Reddy, and Nanja Reddy. One of sons, Kaveri Reddy, and a son of Nanjappa, mortgaged his share to one Doddaya under a registered mortgage deed. As Kaveri Reddy has failed to discharge the mortgage, Doddaya filed suit in OS number 93 or 53 on the file of Principal Second Municipal Bangalore. Said suit came to be decreed. Sri Doddaya purchased the entire mortgage property in the public auction by due process of law. Thereafter, and Doddaya sold the entire land in favor of Kempraju. Present appellant contends that since the date of purchase, he is in possession of the properties as lawful owner. Further, he has submitted that the proceedings under the Inam Abolition Act is pending before Special Deputy Commissioner in respect to these properties. R1 to R4.
That is section 9 applicant.
Yeah, section 9 and 10. And please see his own statement which he has made there. R1 to R4 are the petitioners in the said proceedings. These respondents who deprive the right of the appellant have not made him a party in the above said proceedings. The appellant being the absolute owner of the properties and for proper adjudication, he filed an application to implead him in the proceedings under Order 1 Rule 10 CPC, but the R6 dismissed the application on 1/10/2003. Aggrieved by the order, he approached before the tribunal to quash the order passed by R6 and permit him to implead as respondent in the proceedings before the Special Deputy Commissioner. Appellant contends that he has vested interest in the land in question without hearing his application, application was rejected, is against the principles of natural justice and relied on certain rulings, my lord. Then, if my lords kindly come to page 204, are the reasons. My lord. 204 is reasons, point number 1. That's on delay. I won't trouble you lots with delay. But please come to page 205, point number 2. Present appellant's father Doddaya has purchased the land in court auction in OS 93 or 53 under process of law. He sold the land to the present appellant on registered sale deed. Under Inam Abolition Act, Special Deputy Commissioner held a proceeding in so-and-so. In the proceedings, appellant along with others filed an application on Order 1 Rule 10 CPC to implead him in the proceedings as he is having a vested interest in the landed property involved in this case. Order 1 Rule 10 is then extracted. And then at the bottom, last para, the expression at any stage of the proceedings conform a very wide description of the court in the matter of additional striking of parties, even at a later stage or even at an appellate stage. The only main aspect has to be seen on this point, on the next page.
Where is that only main aspect?
The last line, at the bottom of the page, 205. The only main aspect has to be seen at this point, that the presence of a party, whether necessary, to adjudicate the matter for complete and effective adjudication of subject matter. Present appellant had vested interest from the time of purchase of land in a court auction. Above proviso speaks that whenever a person is having interest in the litigation, he may be added as a party in disposing the case effectively.
So against this order, to the challenge before Lana Singh,
this order was, my lord, in the year
under Order 1 Rule
1 Rule 10.
Where is the main order of the tribunal which was challenged before Lana Singh?
Oh, that order, my lord. No, I was only pointing this order to show as to how he came into the proceedings for the first time.
There is separate order.
Yes, ma'am. That order I'll show you, Lord.
So that is upon which application?
That, my lord, is on everyone's arguments. Everybody. There are several applicants, my lord, which your lordships will find.
And in which this claim was rejected?
In his claim was rejected. And in my humble submission, rightly.
Where is that? Just
I'll take your lordships to that order.
Just refer the page.
Yes, ma'am. Annexure. Page 217, my lord. Annexure K, page 217.
Yes.
And the consideration of the land tribunal with respect to Kemparaju is at page 229. 229. Last paragraph on page 229. The fifth petitioner starts.
So that order 110 was granted.
Order 110 was granted. The High Court also said you can proceed. But that does not confer a right on you automatically. And that was a statement specifically, my lord, made by the learned single judge at that point in time, saying mere impleading does not give you a right.
But in normal circumstances, yes. But in this case, his impleadment was in the recognition of his capacity to claim the grant.
No, it's all it said was he is required for
impleading
for a final determination this
his
proceeding.
capacity to claim the grant was recognized.
No, because that recognition can only happen in the final order when the rights of all parties are determined. In Order 1 Rule 10, Lord, he's made a claim. He says he's bought it under court auction. Court says will implead him. But whether he has a right or not, please see the finding, my lord, of the...
You were there in this proceeding?
Yes, I'm there. I was there, my lord, in this proceeding. And
all were heard.
All were heard. All were heard and this decision was taken. Page 207, if my lord just sees the order of the High Court, the order of KAT was then challenged before this High Court.
Need not.
No, I'm only saying what the High Court said was the right, that impleadment does not mean his right is recognized.
It's said by the High Court.
Beg your pardon?
So observed by the
Yes, it is observed by the High Court. That's why I want to show that.
Yes. Page?
Page 207 at page 211. Para 7. It is well settled that when a person is interested in the proceedings, he may be permitted to come on record. It is necessary to hear him also. And merely because...
So there was no application under section 9?
No application under 9 and 10, nothing, not an application. Because if that was there, why should he implead? He would simply say, my application is there, consider my application. No concept of impleadment. Now the order below of the land tribunal lordships wanted 229. As the contentions, my lord, of Kemparaju. I won't trouble your lordship with that. If my lords kindly come to 232. And I'm sorry, 237, my lord, Kemparaju's claim, how it is considered. 237. I am not troubling your lordship with other consideration because the matter is remanded insofar as that is concerned. Insofar as.
Need not read.
That's, he says it is not filed in 1979 before 31/12 and it's barred by limitation.
So we'll end here.
This is where we are. And then now.
If your link is getting.
No, now, my lord, I can take your lordship to learn a single judge's order as to how the learned single judge, my lord, has considered his claim and has granted it and whether that can be right or not.
Tomorrow? Yes. Tomorrow or any other day?
2:30, my lord.
Tomorrow? No, use.
Could your lordship fix up at 2:30?
You are for?
I am for the respondents, I am only, my
Actually-
learned friend kept saying that I'm not concerned about the other matters. Anything what to affect us or not, I will just point out. Otherwise, I am.
I am the contesting the.
Insofar as their claims are concerned, there's no challenge in this proceeding.
Something happens.
No, I'm not saying you should, I'm not saying he shouldn't be heard if he wants to, but I'm just saying it is not there. You don't want. Tuesday.
Any day. Any day.
Or like Monday.
Monday.
Not Monday.
Monday and Tuesday.
I mean, next Monday means next working.
No.
Could your lordship fix up the date so that.
Can it be second? I'm sorry. Second.
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 So Wednesday.
First better. I have some difficulty in first.
Wednesday.
And first is best avoided. First is best avoided.
Could your lordship fix the day, time, my lord, at 2:30?
I'll not make any comment.
I say.
So, second.
Second. Great.
In Gujarat, newspaper carry all hoaxes, all rumors by way of news item on 1st April.
First.
2:30. Second, 2:30. Yes, your matter.
Great.
The last matter.
Has your lordship fixed the time, my lord, at 2:30? That's my fault.
Or shall we keep it at 3:30? Mr.
Answer.
3:30?
3:30.
3:30.
2:30, my lord.
2:30 is better. All right, 2:30.
No.
67,
No, he's to be heard.
number 67.
Okay. For the third respondent.
My lord. Lordship's order dated 5/7/24, your lordship.
End April, huh?
April 25, 2:30. Petition was already disposed of.
Yes, my lord, it's disposed of, your lord. My lord, your lordship, I'm only on this particular point, your lordship.
But this,
Point number 7, if your lordship's order dated 5/7/2024, your lordship.
so you were the applicant for site.
Yes, my lord.
And today you filed what? Anything is filed today?
Yes, my lord. Today I have not filed, your lord.
No. IA is filed. Very good.
IA for consideration is what I have just filed here.
So where do we get that the term of the committee gets expired on 28? Anywhere reference is there?
That is what has been informed to us, my lord.
That is the order, the main order passed in this same case, my lord.
Where is that order?
On 25th August 2012, main order. This petition is already disposed of once. Thereafter, some of them filed the applications.
No. Committee term. You are for BDA.
Yes, my lord.
So committee is not represented by any.
No, committee constituted by this one, but that period was, my lord, this files was not referred to the committee. The para 3 of the application, the order
What
was.
is the order of the state government constituting committee pursuant to direction?
That is in the file. Well, they produced the government has filed the.
We'll allow this application.
Yes.
In the meantime, you find out the document.
Yes.
So that we are sure that it is there.
Yes.
It is allowed in today's date. Tomorrow, day after, tomorrow is 27.
Yes.
Tomorrow we'll get the copy, but in the meantime, just pass over that
Government order.
order of the constitution of committee, which will be showing the tenure of the committee.
Yes, my lord.
Right? Is that? Tenure is not.
That is available.
This is pursuant to our order. Ordinance. That is order dated 17/10/2012. State government had constituted a committee under the chairmanship of Sri Padmaraj to probe into the allotment. Same committee.
That was the first committee, Your Honor. Later on, that committee could not complete the.
Then this court.
This court again, another committee was formed. Right now, presently, by virtue of your lordship's order, only 2 members are constituted now.
So you are saying that your file is not considered?
My lord?
Your file is not considered?
Not considered, my lord. What is coming in way of the committee considering my order is.
Where you have stated that your case is pending? It's two of 25 or one of? Two of 20.
Allowed my affidavit at
So your case was not within 67.
no, my lord.
So how we recorded 67, figure 67?
That was based on the application made by the committee, which requested your lordship that the three members were not able to, by virtue of non-appointment of a fresh.
This file is remaining?
Well, it is remaining, well, it is not considered. It
You are not disputing that?
not disputed.
So
Yes, ma'am.
you agree that his application is pending,
Yes, ma'am. Yes,
required to be considered by committee?
yes, ma'am.
Committee is somehow left out, correct?
Yes.
We'll pass the orders.
Like me, there are other applicants who are still awaiting, because the lordship's order had restricted only to 67.
Because committee said we have only 67 cases pending.
As on that day, yes, my lord.
On that day, your application not pending.
BD had not sent my file at all to them.
So how many files are still pending?
In fact, I just, on my personal curiosity, I just sought details from the committee, my lord, which says that almost another 68 files are still being pending from the BDA to be sent to the committee by virtue of the original order of the year 2012, Your Honor. Just for an assistance of the court, I just secured this information here. Point number 7 of your lordship's order is coming in way, Your Honor.
IA number 2 of 25. Third learned Advocate Mr. Chandrachud.
Chandrachud.
For the your petition.
I'm an applicant who has filed this application.
Third
Yes,
party.
third party.
Applicant. Learned Advocate Mr.
K. Krishna for BDA. K. Krishna for third respondent.
for Bangalore Development Authority. Paragraph. This application is filed.
Two applications, my lord.
Two applications.
Two applicants.
This application filed by two applicants.
Yes, my lord.
No,
Two
separate, they filed a separate.
Two separate
application.
applications.
So I-1 of 25 and 2 of 20.
Yes, my lord.
These applications are filed by two applicants who are not party in the main proceedings of writ petition number 23475 of 2010. The prayer in this application, the two applicants is that the committee which is considering the cases for allotment of site should also consider their case, which are according to the applicants are left out. Paragraph. Writ petition number 23475 of 2010 addressed the issue of allotment of sites. The petition was disposed of on 25/8/12. Full stop. In the order passed by a single judge on 25/8/12, disposing of the petition, one of the direction in paragraph 28 in duplicate small Roman 2 was that the government shall constitute a committee of 3 members. Full stop. The committee was constituted in compliance of the directions comprising of 3 members. Subsequently, in view of the demise of one of the members of the committee, this court by order dated 5/7/24 appointed directed that the committee shall function with the remainder 2 members and deal with the pending cases. At that time, paragraph, as recorded in the order and as given out by the committee, from out of 834 cases, 767 cases came to be disposed of, and 67 cases remained pending for disposal. In that light, the court in the said order dated paragraph, in that light, the court in the said order dated 5/7/24 observed thus in paragraph 7. So court paragraph 7, here it is. In the present application, the case of the petitioners applicants are that their applications which were required to be considered by the committee for the purpose of allotment of site were not sent by the Bangalore Development Authority. And therefore, they were not part of the 67 pending applications which were referred to in the aforesaid order dated 5/7/24 and which were directed to be disposed of by the committee. Full stop. The effectum of pendency of the applications by the 2 applicants is not disputed by learned advocate appearing for the Bangalore Development Authority. He also concurred that the BDA had not sent those applications by inadvertence. In the aforesaid view, there shall be notice to the respondents. The committee, which is functioning as on today, is directed to deal with and decide the applications of the 2 applicants before the returnable date. So notice returnable on 22nd April before the returnable date. Full stop. It is further provided that if the term of the committee is going to expire before the returnable date, the committee shall continue to function by virtue of the present order of this court to function so as to decide the applications of the applicant. Paragraph. Additionally, it is not becoming clear as to whether there are still other applications pending with the committee beyond 67 applications added by the 2 applications of the present 2 applicants. Also, according to the learned advocate for the applicants, as per Based of his information, several such applications are pending. Full stop. The committee was constituted, paragraph, to complete this task of considering and deciding the applications for allotment of site. If the applications are still pending, it is in the interest of, it is in the larger interest that the committee deals with all such applications and decides the same. Full stop. Therefore, paragraph. Learned additional government advocate, Mr. Harish, is directed to appear and accept the copy of this order.
Please.
Full stop. He shall maintain contact with the, there is a secretary.
Registrar, I believe.
With the secretariat of the registrar of the committee.
Registrar or
and
secretary.
find
Secretary
out-
is there here.
And find out
Please.
to apprise before the court as to whether any other further applications are still pending with the committee. Yet to be decided. Full stop. In the same way, learned advocate for the BDA shall also furnish
Yes.
the information to the court as to whether any of the applications of the any applicant is still left out, remaining with the BDA to be forwarded to the committee.
Very good.
Notice to, you are appearing for number 124.
My lord, respond. Yes, please.
123. Appears on behalf of 123, directed to
Honorable.
appear on behalf of 123, state and accept the.
Please.
Notice is issued to respond number 123 only.
Please.
And learned additional government will accept the notice.
Please.
Then all, everything.
Deeply obliged.
Having permission, my lord. Matter 81.
Lord,
81.
please, my lord, the awards obtained by playing fraud on the court have been challenged because the land pertained to the whole village. And the respondents are about to issue the compensation of around 2 crores rupees. By way of interim direction, I have prayed your lordships kindly to deposit the amount before this honorable court the matter is decided. Lord, an amount of rupees around 2 crores is being received as a compensation by the persons who have played fraud on the court, manipulated the record of rights. I have prayed for interim direction by I number 1 of 2024 to directing the land acquisition officer to deposit the amount before this honorable court.
81 is PIL.
Yes, my lord. It's a land acquisition. A land belonging to the whole village has been colluded with some other one single family, created documents, and then obtained decrease by being fraud on the court is the ground.
24th April.
May I request to have it on 11th, please? 11th for
11th can be kept.
by 2:30,
Will not come.
please.
My lord,
May-
item
may-
serial number
2:30, my lord.
107.
11th on 2:30, my lord. May I, is my prayer.
11th is working. Holiday. So we will not come on 11th. You can come and argue.
11th is horrible.
Please.
My lord, item 111.
Serial number 80.
Serial number 1,
Holiday.
11th is holiday.
11th is holiday.
Okay. May I request you to have it on 4th?
No, no.
My lord,
It can go 24th.
My lord,
My lord, may I
serial number.
request to have it on 25th. 25th, please.
My lord,
Well, let's
item
make a mention, my lord.
111.
My lord, serial number
Item
80.
111. I understand, my lord, I completely understand. I've been witness to what your lordships have been put through today. My only request is if your lordship may consider accommodating me on the 15th of April
My lord,
and possibly a fixed time or maybe slightly higher up on the board, my lord.
You mentioned on that date, 11.
I'm at 11. I'm so obliged.
We'll take up in course of the day.
I'm so obliged.
My lord, serial number 80, my lord.
Give me that. But number 4 is not served.
Number 4 is not necessary. He's just an inquiry officer. On the last occasion, when your lordship passed the order, I pointed that out. Unfortunately, possibly it's not been recorded in the order. I said I'm giving up 4.
You will delete.
I'm sorry.
You will delete number 4.
Yes, yes.
Lord, serial number 80.
Served on by that date, well and good. Otherwise, if it is served by that date, well and good. Otherwise, you take your own decision.
111, my lord.
If number 4 is served,
please,
for 15th April, well and good.
Very well.
Otherwise, you take a call what to do.
Very well, my lord. He
Lord,
has been made
serial
a
number-
party only because he was a party in the writ petition, my lord. I'm the respondent in the writ petition.
Might be
Very well. Very well.
In
Very
the
well.
said matter, my lord. Number 80, serial number 80 regarding maintainability of the company commercial appeal. May I just request your lordship to kindly permit me to convert it to writ petition because I have challenged under order 38 rule 5 CPC that order is not appealable before the commercial this thing. That's the reason why I may be permitted to convert it into writ petition.
It can't be so converted.
number
So,
one.
see,
That officer has raised the objection, my lord, regarding maintainability. In that context, I am seeking your lordship's indulgence.
Then file IA or something.
Serial number
Not
107.
necessarily, my
Number
lord. There is an
34.
objection. Office objection
serial
raised
number 34, your
in the audits.
So not maintainable.
Serial number one.
Serial number
serial
It
number
says not
34.
maintainable.
Please,
So we
regarding maintainability only.
we
This matter
confirm.
has been posted before your lordship.
We confirm that objection.
Before your lordship, serial number 80 regarding maintainability of the commercial appeal.
Correct. We confirm that objection. On your own saying.
That's the reason why I'm seeking your lordship to kindly permit me to convert it into
Not, we can't grant conversion.
serial number 31.
File afresh.
Serial number 107.
Serial number
File afresh
34.
and withdraw this.
Serial number 107. There's some extreme urgency. Kindly have it on tomorrow, my lordship.
Serial number.
Serial number 34, your lordship.
Fourth respondent has awarded the contract in favor of Rajashri Electrical Company, who is not a manufacturer. So without following the KRC guidelines, award has been granted in favor of, have it on tomorrow, my lord.
Four.
Serial number 31, my lord.
Serial number 34.
Serial number 31, there is some urgency, my lord.
One second. Serial number 118 may be called on 3rd April.
Lordship, serial number 66.
118 serial number. May be called on 3rd of April. Other two matters.
Your lordship 31, my lord.
My lords, may I make a mention, my lords?
107